is 9 a.m.
Yeah. Are you having good weather?
Yeah. It's
Good.
Pretty close here.
Here it's almost 9 p.m.
Yeah.
I think it's maybe I think we have snow outside.
Really?
Yeah, it's very cold. It's so cold.
Okay. Kevin, this is Yuan. Maybe Yuan, you can.
Hello, Prof. Kevin. My
How are
name is
you?
Muhammad Yuan. I'm fine, good. How are you?
I'm good. I'm good. Very cold.
Understandable. So I will be the moderator for this webinar today.
Wonderful. If only I could get my hair to behave. It's -6 today. -6.
Oh, really cold, right?
Yeah.
There. Okay.
I don't like it. I wish we had weather like yours. It's very warm there, right? Like normally your climate.
Yeah, we are very warm here, around 28 to 30 something.
Yeah.
No, it's hot, really hot.
I went to Jakarta and Bali when I was a child, so it was a long time ago, but I remember it being just warm and tropical and beautiful. And
Yeah, I will wait you in Bali, right?
huh?
I will wait you again in Bali. Yeah.
My wife wants to know if I can bring an assistant because she wants to come too.
Okay. Kevin, this is Ma'am Maria as a Master of Ceremony today.
Hello,
Wonderful.
Kevin. Good morning,
Hello.
Kevin.
Good evening.
Good evening.
And this is Rector UISU, Mr. Rianhar, and we have Dean of UISU, Universitas Islam Sumatera Utara in Medan. Yeah. And we have Nasya here for translator from English to Indonesia. We have interpretation here. Okay.
We still have maybe 10 minutes, I think, before we're scheduled to start, right?
Yeah, right.
Okay.
Oke, Mem Maria, aman ya? Kita bentar lagi 10 menit akan admit semua peserta.
Oke.
Langsung kita mulai. Untuk ini, play bumper dulu.
Lo nanti kasih tahu kalau kita udah boleh mulai ya.
Siap, Mem. Ntar Flo akan ini, sorry, akan play bumper dulu. Ini
Oke.
Bapak izin saya jadikan co-host untuk Bapak Rektor. Mohon maaf, Bapak. Untuk Pak Faisal, apakah sudah hadir nggih, Pak Daud?
Lagi proses, Mbak Flu.
Oh, nggih, Bapak. Siap. Halo, selamat pagi Pak Faisal.
Ya, selamat pagi.
Iya. Pak Faisal sehat hari ini?
Sehat, alhamdulillah.
Siap semangat nih Pak
Ya,
untuk mengisi acara pada hari ini. Oke, kita mulai acaranya 5 menit lagi ya Pak.
baik, saya tunggu. Terima kasih.
You guys have the fancy backgrounds. I need to get one of those.
Oke. I will send to you ya.
No, it's fine.
Yeah, in chat, it's okay. We have
Yeah?
to send this to you. Wait. Sorry.
Apakah sudah bisa diterima undangannya? Yang lain sudah dilakukan.
Sorry, Kevin, I have send you email for this virtual background because in chat Zoom I can send the file. Okay.
Thank you. I really appreciate it.
Yeah. Mem, sebentar lagi kita admit peserta dan akan kita mulai nih, Mem. Oke.
Oke, Flo.
Ya. Mungkin sebelumnya kita bisa berdoa untuk kelancaran acara pada hari ini. Mungkin Mem boleh pimpin, Mem.
Baik, Bapak Ibu sekalian, sebelum kita memulai acara webinar internasional kita hari ini, baiklah kita berdoa menurut agama dan kepercayaan kita masing-masing. Doa kita mulai dengan membaca Al-Fatihah. Doa selesai.
Oke, baik. Flo izin admit semua peserta. Mungkin untuk Bapak Daud, kiranya nanti boleh disebarkan lagi untuk link Zoom-nya. Terima kasih banyak.
Ya, baik Pak Flu.
Heylaw.edu adalah platform digital untuk belajar hukum terlengkap. Kami punya semboyan, belajar hukum itu mudah. Bahkan bukan sarjana hukum, bisa belajar hukum dengan mudah. Banyak pelatihan, webinar, dan kelas digital hukum tersedia di sini. Tentu dengan para pengajar dari profesional dan dosen hukum berpengalaman. Kami berharap Heylaw.edu dapat menjadi kawan belajar hukum kamu. Iya, kamu!
Heylaw.edu berkolaborasi langsung dengan tenaga ahli, profesor, hingga profesional pengajar di bidang hukum.
Heylaw.edu berkomitmen untuk terus mengembangkan ekosistem pembelajaran yang edukatif, khususnya di bidang hukum. Maka dari itu, kami berkolaborasi dengan berbagai pihak untuk mewujudkan pembelajaran yang lebih baik di masa depan.
Di Heylaw.edu, belajar mudah, lebih hemat dengan berlangganan.
Dapatkan penawaran menarik dan kemudahan belajar hukum hanya dengan membeli paket bronze senilai Rp99.000. Anda akan mengakses semua kelas reguler, bahan ajar, dan juga sertifikat loh. Paket silver dari Rp700.000 sekarang hanya Rp299.000 selama 3 bulan. Lebih hemat bukan? Anda akan dapat akses semua kelas reguler, bahan ajar, sertifikat, serta update kelas baru. Jadi nggak ketinggalan kelas lainnya. Gak cuma itu aja, Anda juga dapat memilih paket gold dari Rp2 juta menjadi Rp980.000 selama 1 tahun. Anda sudah dapat akses semua kelas reguler, bahan ajar, sertifikat, update kelas baru, buku dan publikasi Heylaw Mitra, bahkan ada souvenir dari Heylaw juga loh buat Anda. Banyak kan untungnya? Tinggal klik langganan pada bagian atas, pilih metode pembayaran, lalu Anda sudah bisa mengakses semua kelas di Heylaw.edu. Mudah bukan? Jadi, tunggu apa lagi? Yuk berlangganan sekarang. Bisa scan barcode sekarang juga.
Fakultas Hukum Universitas Islam Sumatera Utara menghasilkan lulusan sarjana hukum yang profesional, jujur, dan berjiwa islami dalam menegakkan hukum.
Fakultas Hukum Universitas Islam Sumatera Utara adalah merupakan fakultas hukum yang tertua di luar Pulau Jawa. Sudah berdiri sejak 7 Januari 1952. Dan Fakultas Hukum Universitas Islam Sumatera Utara telah menghasilkan berbagai lulusan di berbagai bidang, baik di instansi pemerintah maupun di instansi swasta. Fakultas Hukum Universitas Islam Sumatera Utara semakin berjaya sehingga mampu menghasilkan lulusan Fakultas Hukum UISU yang berjiwa islami, profesional, dan berintegritas baik dalam persoalan penegakan hukum maupun di dalam pembentukan hukum.
Baik, kita akan memulai acara kita pada hari ini. Assalamualaikum warahmatullahi wabarakatuh. Good morning and best wishes for all of us. Respected Rektor Universitas Islam Sumatera Utara, Dr. Haji Yanhar Jamaluddin MAP, as well as all the vice rectors. Respected Dean, Faculty of Law, Universitas Islam Sumatera Utara, Dr. Marzuki SHM, and all vice deans. Respected Director of Heylaw.edu, Dr. Awaluddin Marwan SHMH.MA, all speakers, Professor Kevin W. Jennings, and Dr. Muhammad Faisal, SHMH. Respected all team members of Heylaw.edu who have assisted the committee of this international webinar. Lecturers of the Faculty of Law, University Islam Sumatera Utara. All students of the Faculty of Law, Universitas Islam Sumatera Utara, and all participants of this webinar whom I cannot mention one by one. Praise be to Allah, the Almighty, because of His conscience we have been given health, so that we can come together today, Monday, 24 January 2021, at the International webinar. This webinar is held for the purpose of the milad of the Faculty of Law, Universitas Islam Sumatera Utara. The webinar topic itself is Common Legal Issues Faced by E-commerce Transaction in Indonesia. Finally, let us say salawat and salam to the Prophet Muhammad SAW. Hopefully, we will get his syafaat in the judgment day. Amin. Amin ya Rabbal Alamin. Makan nasi, gulainya telur puyuh. Jika pedas, jangan mengeluh. Selamat milad Fakultas Hukum ke-70. Tetap semangat walau usia sudah sepuh. Later is the reading of the Holy Quran and is followed by invocation by Mr. Amir Pohan. To Mr. Amir Pohan, we kindly invite you.
Yas'alunaka 'anil الذين يقيمون الصلاة ومما رزقناهم ينفقون أولئك هم المؤمنون حقا لهم درجات عند ربهم ومغفرة ورزق كريم لهم درجات عند ربهم ومغفرة ورزق كريم صدق الله العظيم.
Thank you, Mr. Pohan. Singing the Indonesia Raya, our audience are requested to stand up.
Yeah.
Audiences are pleased to be seated. Opening speeches. Forward by the Dean of the Faculty of Law, Universitas Islam Sumatera Utara, Dr. Marjuki S.A.M. Hum. To Mr. Dean, we kindly invite you, sir.
Assalamualaikum warahmatullahi wabarakatuh. Selamat pagi dan salam sejahtera bagi kita semua, serta selamat malam kepada Prof. Kevin W. Jennings. Pertama sekali kami menyampaikan terima kasih kepada Rektor Universitas Islam Sumatera Utara yang telah memfasilitasi webinar internasional ini dalam rangka 70 tahun Fakultas Hukum Universitas Islam Sumatera Utara. Demikian juga terima kasih kami kepada Heylaw yang dipimpin oleh Bapak Dr. Awaludin Marwan atas kerjasama dan perhatian kepada Fakultas Hukum Universitas Islam Sumatera Utara dalam rangka peningkatan kompetensi dosen dan mahasiswa melalui webinar serta kualitas akademik Fakultas Hukum Universitas Islam Sumatera Utara. Terima kasih juga disampaikan kepada Prof. Kevin W. Jennings dari Lincoln Memorial University serta Dr. Muhammad Faisal dari Fakultas Hukum Universitas Islam Sumatera Utara yang telah bersedia menjadi narasumber dalam kegiatan webinar ini dengan tema Common Legal Issue Faced by E-commerce Transaction in Indonesia. Diharapkan dengan tema tersebut dapat mengantisipasi problem yang timbul dari kegiatan transaksi e-commerce sejalan dengan era revolusi industri 4.0. Semoga dengan webinar ini dapat memberi manfaat bagi kepentingan masyarakat, bangsa, dan negara. Akhirnya diucapkan terima kasih kepada semua pihak yang berpartisipasi dalam kegiatan ini. Terima kasih. Wassalamualaikum warahmatullahi wabarakatuh.
Waalaikumsalam.
A speech by Rector, Universitas Islam Sumatera Utara, and opening this webinar to Mr. Rector, Dr. Haji Yanhar Jamaluddin, NAP, we kindly invite you, sir.
Assalamualaikum warahmatullahi wabarakatuh. Selamat pagi dan salam sejahtera buat kita semua. Dan especially good night for Mr. Kevin Jennings. Kami mengucapkan selamat milad Fakultas Hukum Universitas Islam Sumatera Utara ke-70 pada tanggal 7 Januari 2022. Semoga Fakultas Hukum terus dapat berupaya menuju Fakultas Hukum UISU yang unggul sesuai dengan moto membangun sinergitas menuju UISU unggul. Building Synergy Towards Excellent UISU. Pimpinan Universitas mengapresiasi kegiatan webinar ini dengan tema Common Legal Issues Faced by E-commerce Transaction in Indonesia. Dan diharapkan dengan kegiatan ini Fakultas Hukum Universitas Islam Sumatera Utara mampu menjadi problem solving dalam mengantisipasi persoalan transaksi e-commerce berbasis IT. Selanjutnya, terima kasih dan apresiasi kami sampaikan kepada Heylaw sebagai mitra kerjasama Fakultas Hukum Universitas Islam Sumatera Utara menjadi fakultas yang go internasional. Semoga pula kegiatan ini dapat meningkatkan akreditasi bagi Fakultas Hukum Universitas Islam Sumatera Utara. appreciate and thanks for Mr. Kevin Jennings from Armstrong University and Dr. Muhammad Faisal from Faculty of Law, Islamic University of Islamic University of North Sumatra as speakers. Then by saying Bismillahirrahmanirrahim, the webinar with the theme Common Legal Issue Faced by E-Commerce by the Faculty of Law, Islamic University of North Sumatra, and Heylaw begins. Happy webinar. Wassalamualaikum warahmatullahi wabarakatuh.
Waalaikumsalam warahmatullahi wabarakatuh. Thank you, Mr. Rector. The next agenda is photo gathering. We would like to invite Rector and Vice Rectors, Dean and Vice Deans, all speakers, and participants webinar. All of you should turn your camera on. Thank you. Miss Blue, would you like to take a photo, please?
Okay, Ma'am Maria, I will count in for first slide, okay? 3, 2, 1. Wait. Okay.
Okay. We have already finished the ceremony opening of the International webinar. The following is the core agenda of the International webinar entitled Common Legal Issues Faced by E-Commerce Transaction in Indonesia. With sources, Professor Kevin W. Jennings from Lincoln Memorial University, titled Common Legal Issues Faced by E-Commerce Transaction in Indonesia and Digital Forensic. Dr. Muhammad Faisal SH.MH, Rector of the Faculty of Law, Universitas Islam Sumatera Utara, titled Legal Challenges in Digital Economy Era, Issues in E-Commerce Transaction. With the moderator, Muhammad Yuan Family. He is studying at the Faculty of Law, Universitas Gadjah Mada, UGM, batch number 19. Once represented, Indonesia in International Client Consultation Competition, ECCC, at Wallace, United Kingdom. Then, I would like to invite kindly the moderator, Muhammad Yuan Fanli. He will chair this webinar. To Muhammad Yuan Fanli, please take the time and space. Thank you.
Thank you, Bu Maria, for your great introduction of me. Am I audible? Bu Maria, am I audible to you, Bu Maria?
Yes.
Okay, right. So as Bu Maria mentioned, we have two speakers for today's webinar. The first one is Professor Kevin Jennings and then Dr. Muhammad Faisal. And I would like to invite Professor Kevin Jennings to have his webinar started if he would like to.
Absolutely. Thank you very much. Let me see if I can get this share screen thing to work. All right, is that working?
It does.
I have to warn you, I'm kind of just getting over being sick, so I may have to mute myself to cough a little bit during this presentation. I assure you it will be very brief, and the good news is it's not COVID, but I was very sick for about 2 weeks. So anyway, today we are going to talk about e-commerce, how that fraud happens, and then what are some of the legal and technical issues with trying to investigate it. And a lot of those legal and technical issues are kind of important and can apply to many different kinds of cybercrime. But e-commerce fraud is either the most popular kind of cybercrime or definitely near the top of the list, depending on who you ask. So first, there we go. All right. Pardon me. So a few years ago, they did a big survey of 25 different countries, and knowing my country, it was almost undoubtedly like Western Europe, America, Japan, and Australia, because we are not very good at caring about the rest of the world here in the United States. But in that survey, they found that over half of people already, and remember, this is a few years ago, already more than half of people shop online somehow at least once a month. In my house, it's a lot more than once a month. We're constantly ordering books and groceries and clothes, and my wife especially. Don't tell her I said that, but she orders way too much from online. So here in the United States, it's about 2/3 that shop online at least monthly. And again, I'm way above the average for that. This kind of fraud, though, doesn't just happen when you're shopping online. This kind of fraud can happen via email, via text message. Social media is really, really big with e-commerce fraud of different kinds. And maybe the most depressing part about it is that so few people, when they're a victim, so few people report to the authorities. And there's lots of reasons for that. Sometimes people don't even realize they're a victim, which can be difficult. But there's also just kind of this overriding belief that the police either can't or won't do anything about it.
Melaporkan kepada pihak terkait, yaitu kepolisian di Amerika Serikat.
The offender is in a different country, because one of the common themes in cybercrime is that if the offender and the victim are in two different countries, it's incredibly difficult or impossible to get any kind of punishment. Usually it's only for big major cases with tens of thousands or hundreds of thousands of American dollars worth of damages. So one kind of subset of e-commerce fraud is fraud via email. And this has become a lot easier as more and more people have an email address. I still, I'm old enough to remember when not everybody had email.
Karena seperti kita ketahui, seluruh masyarakat sekarang itu sudah memiliki email. Seperti itu.
And of course, immediately got scams. So I had to learn very quickly what emails are real and what emails are fake. And it's still difficult, now.
Dan sangat sulit sekali untuk melacak apakah itu email asli atau itu adalah email palsu yang digunakan untuk melakukan penipuan. Seperti itu.
And actually this kind of scam is hundreds of years old. It's just become a lot more popular with the invention of email. But the 419 scam is the classic Nigerian prince, right? Somebody sends an email saying, "Oh, I'm a Nigerian prince and I have $100 million that I need to get out of my country. And if you help me by allowing me to use your bank account, I will give you 10%, which, if you're good at math, is $10 million. And so people are like, oh, all I have to do is let you use my bank account and I get $10 million. Absolutely. But of course, it ends up being a scam, and these people get their bank accounts taken over or some other kind of financial loss. But interestingly, it's called a 419 scam because in the country of Nigeria, which is where it's very popular, It didn't originate there and it's not exclusive to there, but it's very popular there. This kind of scam is under section 419 of their legal code. Pardon me again. So those kinds of scams are very, 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 very popular, especially when America invaded Iraq in 2003. There were a whole bunch of these where they shifted it from a Nigerian prince to an Iraqi prince of some kind, and they needed to get money out of Iraq and would pay you if you helped them. Another very, very common kind of email fraud is called phishing, but not phishing with an F, like putting any fishermen in the audience? Anybody like to go fishing? I love it, but I'm very bad at it. But in the computer, phishing with a PH is an illegal scam where you send out lots of emails trying to pretend to be somebody you're not, or an organization that you don't represent or work for, to trick the people who receive your scam emails into giving you some information that you want, usually username and password for some website. So many times you'll get an email that says, oh, we are from the bank. We need you to give us your username and password so we can verify your account. And if you think it is actually from your bank, you put in your username and password, you get a website that says, thank you very much. And then the bad guys have your username and password. It's incredibly, they have very low rates of people actually falling for it, but unfortunately, when you can email 1 million people, even if only 1% fall for it, you still get a lot of usernames and passwords. Spear phishing is when you can really kind of choose a much smaller group to more effectively craft your phishing attempt to make people more likely to fall for it. So say your university. If I got a collection of emails just from your university, and I was able to send out an email making it look like it came from the president or vice president or somebody important at your university, and I could use their, the university branding and the images and things, and say, hey, there's a problem with your student account, and we need you to put in, reply with this information so that we can fix this issue, and really make it sound like it's coming from somebody at your university. That would increase the number of people who will fall for it. So it makes the victim pool much smaller, but the kind of successful scams are much higher. And then finally, you get even more specific, you get down to what the bad guys call whaling, which is, again, essentially the same process, but you're targeting like one person. In 2016 in the United States, one of our presidential candidates, their head of their campaign fell for one of these whaling scams, and their email address was stolen by hackers who then released a bunch of emails damaging that presidential candidate's chances in the election. Work at home scams. These are usually, you send out a bunch of emails telling people, oh, you can make a whole bunch of money working from home, make $100,000 a year, working from home from your desk and not doing anything big. But usually these are, if you reply that you're interested, they'll say, oh, all you have to do is send me $100 and I'll send you information about how to do this. And then you either never get any information or it's some bogus thing about, buy and sell real estate or something stupid. Secret shopper scams are where you can tell people you'll pay them to become a secret shopper, and all they have to do is go to a store and purchase some product and then mail it to a person, and you'll get reimbursed for the product, and you tell us how the people who work at the store were and all these things. But of course, you go to the store, you buy the thing, you ship it to the person, and then you never get reimbursed. They just used you to kind of send them a free, could be tennis shoes, could be jewelry, whatever. Romance scams are when you get somebody to fall in love with you online and then use them either for a shipping scam like the secret shopper scam does, or sharing their financial info or whatever. And then also via email, you can do what's called a pump and dump stock fraud, where the bad guy will buy a whole lot of shares of a very cheap stock, then send out a giant email talking about how this company is about to release some groundbreaking new technology and everybody should buy the stock. So lots of other people buy the stock, the price goes up, and the scammer sells theirs for a huge profit before everybody realizes the email they got about that company was a fraud. Similar to email scams, there's spam. And spam is just trying to sell something via email. It's advertising via email. And even before email existed, we would still get spam. I don't know how it works in Indonesia, but in the United States, I still, I walk up the street to get my mail at my mailbox, and I open it, and there, every day there's at least a couple pieces of advertising. But usually those are from legitimate companies, at least. Whereas with email, much of the time it's a non-legitimate company. They send out a bunch of advertisements, buy this medicine, or buy this, cheap sunglasses, or cheap this or cheap that. And what makes it easy is you can actually have logos and artwork from the actual company, which is so easy. All we have to do is go to a website and download a file, and now we can use the company's logo for anything we want, right? But of course, if people do actually order from you, they either get a fraudulent product or nothing at all, right? So, a medicine here in the United States is $100 a month, but I just got a spam email that says I can buy it for $10 a month from this company. So I send them, $10, and I either get a pill that doesn't work, it's just a sugar pill or some other kind of, not the medicine I'm hoping to buy, or I just don't get anything at all. I mean, this is just an example of how you can have a company's branding and logo on an email that you can send out to make people believe that they're buying something from a company if it's not actually them. But yeah, one of the dangers of ordering online, especially via spam email, but also just via any non-reputable source, especially if they're in another country because of the difficulties with investigation and prosecution, you have to worry about getting nothing at all, or if you do get something, it's counterfeit. Especially auction sites, eBay or Craigslist, or now they have Facebook Marketplace. Often, if you purchase something via one of those services, you don't get anything, or you get something kind of like what you ordered, but not exactly what you ordered. So some kind of counterfeit product. Or people are using those sites to sell stolen goods. So if you did get what you wanted and got it for a really great price, there's a very high chance that whoever you bought that from stole it. Of course, there is a huge amount of fake goods coming from China. The Chinese are very, very good at taking some product and kind of manufacturing it themselves with their own standards for far, far, far cheaper, and selling it as if it was the real product. And then here in the United States, I mentioned online prescription drugs. We have a very, very expensive healthcare system here in the United States. So especially elderly people who need more drugs, but also have less money, are trying to get cheap drugs. And one of the ways they do that is to order online from other countries. And when they do that, there's a 90% chance that they're just getting sugar pills or some other kind of, a pill of some kind with no active ingredient. There are some kind of legitimate ways to get prescription drugs from outside of the United States, but they're few and far between compared to the number of scam sites that are doing this. Oh, pardon me. Kind of one of the more famous e-commerce frauds, of course, is just identity theft. And identity theft is a very broad term. It's a very wide range of very specific actions that all kind of fall under this umbrella of identity theft. But it all boils down to PII, or personally identifying information. And this is everything from your driver's license number, birthday, social security number, credit card numbers, address and phone number even. All that is PII, some of which we want to keep secret more than others. For instance, like my address and phone number, I give those out all the time, but they can be useful to bad guys in combination with other PII in order to commit many different kinds of fraud, right? There's employment or tax fraud, where somebody signs up for a job with my social security number in order to defraud the employer or to defraud the US government on taxes of some kind. There's credit card fraud, where people use either my credit card or a credit card they obtained in my name to buy a bunch of things. And to rewind back to the last slide, when they do that, they usually sell them on eBay to convert it back into cash. People do phone or utility fraud, where if they're only planning to stay in a certain place for a month or two, they put their utilities in somebody else's name using their PII, never pay them, and then the utility company or the phone company goes after the person whose PII they used instead of the person who actually signed up for the utilities. That actually happened to my wife about 10 years ago. Somebody used her name and information to set up a phone account. There's bank fraud, where you can use somebody's PII to set up a bank account and get, say, a checkbook, write a bunch of bad checks. There's health insurance fraud, where people make fake claims for reimbursement for some kind of health, they contact the health insurance company and said, hey, I paid $10,000 for a surgery, I need reimbursement. And they get reimbursement, but the person they sent the money to isn't actually the person that has that health insurance. And then, of course, there's identity theft for the purposes of concealing your identity from law enforcement, right? Many people are wanted by law enforcement. They don't want to get caught. So they steal somebody's PII who is a law-abiding citizen and make fake driver's license, fake passport, some other kind of fake identification. And then they won't be captured and arrested or put in jail for the crimes they've committed. And of course, anywhere in the world, you have to worry about that exact problem when it comes to terrorism. There are lots and lots of people we suspect of terrorism. We don't want them in our countries. But if they can get the personal information of somebody else and make a fake passport, they may be able to come into our countries to commit these horrible acts. Or if they're already in our country, they can more easily get around or get into a government building, or they can advance their goals a lot easier with somebody else's personal information. And we always have to worry about that. So when somebody steals your identity, they can either use your existing accounts or they can create some new account in your name, right? So, I'm ostensibly an expert in this subject, and this still happens to me. twice in the past 5 years, somebody has stolen my credit card and made a bunch of charges, and it wasn't me. Luckily, my credit card company was very good about it, very understanding, and they fixed the problem, and I wasn't liable for any money. But you know, even somebody like me gets their credit card stolen, again, twice in the past 5 years. But even kind of more dangerous is if they create a new account. If somebody were to use my name and social security number and all those things to get a new credit card account and charge a bunch of stuff, it would take a lot longer for me to notice that. When people stole my existing credit card, I noticed that there were charges fairly quickly. But if I don't know to check the account, because I don't know the account exists, they can do the scam a lot longer. You know, it could take months for me or any other victim to figure out that they are a victim. And what's really scary and sad and difficult is that most of the time, in fact, I would say, we don't know how it happened. You know, I had my credit card stolen twice. I have no idea how. It could have happened in any one of maybe 100 different ways. And I have no idea who stole my credit card or how they stole it or what I can, you know, any specific thing I could do to protect myself better. I have no idea. But there are lots of different ways to get this personal information. One of them is just going through the trash. I'm not sure about Indonesian law, but here in the United States, as soon as my trash can goes to the curb, the street, I have no privacy interest. So anybody, law enforcement, bad guys, anybody can search through my trash all they want, and they're not breaking any law. So they can steal, you know, if I get a credit card application and I get a bill from another credit card and I get a piece of mail that says this, and I just throw it right in the trash can, bad guys can go and steal all that mail and use whatever information they find in order to steal my identity and do any one of those frauds and crimes that I listed on the previous slide. They can also do things like, you know, if I go to a store and I use my credit card to buy something and the store has a credit card scanner that is not secure, bad guys can kind of overhear that credit card scanner talking to, you know, Visa or MasterCard or whatever credit card company's servers on the internet. So that scanner has to communicate with Visa or MasterCard or whoever. And if hackers can use these high-tech methods to kind of overhear that conversation and steal your information that way. So there's all kinds of different ways you can get your personal information stolen. And then once it's stolen, here's where it gets really kind of scary and but also interesting from my perspective, at least. There are markets online where it's like eBay, but instead of buying shoes and clothes and things, you buy personal information, especially credit card numbers. There are websites on the dark web, which is I can give a whole other lecture on the dark web, but it's a place where a lot of crime happens. It's very difficult for law enforcement to track. It's kind of a much quieter, closed off section of the internet. But they have these websites where you can buy stolen credit card numbers. And they're fairly cheap too. I mean, you can buy a Visa for, I think last I looked, it was like $10. You know, $12 for an American Express and $8 for a MasterCard and all these things. So you can buy credit card numbers by the hundreds or thousands if you want. You can also buy social security numbers connected to names and addresses and phone numbers and all these things. And these illegal websites they're just like eBay or Craigslist or whatever, in which sellers can get verified, so people are more likely to trust them. And you can do, if a buyer and a seller are both very happy with the transaction, they can do ratings. And interestingly, they even have escrow, which is where, buyer purchases something, buyer sends the money for the thing to a trusted third party, seller sends the buyer whatever thing it is, and when both people are happy, the money goes from the trusted third person to the seller. It prevents people from doing other kinds of fraud. And all these kind of wonderful, positive aspects of purchasing online are still there, even if you're purchasing illegally obtained information. Just blows my mind. But I guess even bad guys have standards. So here in the United States, who investigates e-commerce legal violations? All these different kinds of frauds. The answer is very, very complicated. A lot of the investigation just doesn't happen. If you only lose a little bit of money and there's not an easily identifiable bad guy, nobody investigates it. Is local police. If there's any kind of evidence of somebody doing something in person, whether it's going through my trash or copying my credit card, manually, physically, then it's local police. But at the federal level, so if it's a national or international crime, it's the federal police that do it. But here in the United States, we don't have one federal police force. We have many, many, many federal police forces, and they each have different jobs. So, for instance, the Secret Service. The Secret Service is famous because the Secret Service are the bodyguards for the president, right? I'm sure you guys have seen in American movies or American TV that the Secret Service, they dress in suits, they have the little earpieces, and they follow the president around and protect him. That is actually a small part of their job as an organization. Most of the Secret Service's job is investigating financial crimes. So frauds, counterfeit money, counterfeit products, that all falls to the Secret Service. The FBI, or the Federal Bureau of Investigation, they have a much more broad job or status, but they do a lot of identity theft investigations, and they're one of the major investigators for terrorism. And if that has a cyber component or an e-commerce component, i.e., terrorists use a fake passport or stolen credit cards or whatever, the FBI will investigate that kind of thing. And then we have two organizations, in fact, that are about customs. There's ICE, or Immigrations and Customs Enforcement, and there's CBP, which is Customs and Border Protection. Why we have two organizations doing customs, I don't know. Don't ask. My country does a lot of really weird things. But those two groups are looking at goods either coming into the country or being sent out of the country, and money going in and out of the country. So if there's some kind of e-commerce fraud that is international, those two groups tend to look at the goods that are being shipped, whether they're fraudulent or illegally obtained, and then money going in and out. In the UK, England and Scotland and Wales and that country, with the Queen, has the big fancy hat, looks really heavy. Anyway, in the UK, they have their kind of version of the FBI is the National Crime Agency. They have a national cybercrime unit, and that's the federal police force involved in investigating these kind of online frauds and scams and things. Now, we've talked a little bit about kind of what the frauds are and how they work and how they're investigated and all these things. Now we got to talk about the legal impacts, the legal challenges, the legal issues. So here in the United States, again, all 50 states have laws against these kinds of crimes, plus the federal government has laws against them. So you can't hide from either state or federal law when it comes to identity theft and fraud and counterfeit goods and counterfeit money and all these problems. And if you're caught, not only can you be punished with jail or fines paid to the government, but you can also be ordered to pay restitution to the victims, right? So if I scam 100 people out of, $1 million total, I can be forced to pay them back, no matter how long it takes. I could work the rest of my life to have to pay them back, the victims of scams and frauds like this. One of the major issues when it comes to law and e-commerce is violation of intellectual property laws. And the good news is here there is a lot more international law than in most kinds of e-commerce fraud and theft and those other crimes. If it's intellectual property violations, there is actually some international law in place to help us investigate and prosecute this. One of the big ones was this thing called the Bern Convention, and Bern is a city in Switzerland, I think, and they made a kind of an international agreement there way back in 1886. That's not a typo. It was really 230 something years ago. And at the time, there was like 20 countries that signed it. But that has since grown to almost every major country on the planet. And before this presentation, I checked, and Indonesia did sign on to the Bern Convention. I want to say it was like 1997 or something, but Indonesia is a signatory for the Bern Convention, meaning that copyright violations and how copyrights work and how intellectual property works, all those countries, again, which is almost every country on the planet, has agreed to protect those copyrights and intellectual property issues. Also through the United Nations, there's a World Intellectual Property Organization where if somebody tries to pass off fake goods or download or steal music or movies or TV shows or the plans for some product or some other kind of protected information, the UN has a group that investigates that issue. Here in the United States, we have these three major laws that protect piracy and intellectual property. Excuse me, apologize again. But essentially, the short version for the United States is that if you steal somebody's intellectual property using the internet, you can go to jail for a long time and pay a very, very large fine. Now, when it comes to digital investigations, any digital investigation for any crime, but especially things like e-commerce, fraud, anything that involves the communication of two parties, has to meet certain legal standards, right? The investigators have to be very careful not to violate legal standards when it comes to any of this investigation. And these court cases are very, very, very important when it comes to what investigators are allowed to do and what they're not allowed to do. So here in the United States, we have this wonderful piece of our Constitution. It's called the Fourth Amendment. And it says that the American people have the right to be free from unreasonable searches and seizures. And, I'm paraphrasing. But unreasonable searches and seizures, that's the kind of most important part of this amendment. But between 1780, whatever, when it was first written, and 1914, it only applied to federal police. It didn't apply to state police or local police. And there was no kind of punishment or there was no repercussion if the federal police violated that right. Up until 1914, there was a Supreme Court case, Weeks versus United States. And in this case, the Supreme Court created what we now refer to as the exclusionary rule. And what it says is, if the federal police, because we're still only talking about federal police in 1914, but if the federal police violate any of your constitutional rights, but usually it's the Fourth Amendment rights against unreasonable searches and seizures, the federal government violates any of your rights when obtaining some piece of evidence, they are not allowed to use that evidence against you in court. So that's kind of the punishment for the police for violating your rights. And the hope is that if police know that if they violate your rights, they won't be able to use the evidence against you in court. This will prevent them from violating people's rights because they know there's no point in doing it if they can't use it against you at a court trial. 4 years later, 1918, another court case, they expanded the exclusionary rule. So now, not only is any evidence you find in violation of someone's rights excluded from their court case, but now any evidence you found because of that evidence you found is also excluded. So if I violate your Fourth Amendment rights and I find a key to a locker, and then later I use that key to open the locker and find drugs, now not only is the key excluded because I violated your rights to find it, but also the drugs are excluded because I only found them because of the key. And that can go as many steps as you need to go. If you find one piece of evidence in violation of someone's rights, and that leads you to a second piece of evidence, and that leads you to a third piece of evidence, and that leads you to a fourth piece of evidence, every piece of evidence on that whole chain is now excluded. It's not allowed to be used against you in your court case. 1961, Matt v. Ohio. This is one of the most important Supreme Court cases in our country's history, but it's not as famous as many of the other ones, but this one is very important in my opinion, because this is the court case where finally the Supreme Court said, okay, not only does this exclusionary rule apply to the federal government, but it also applies to the state and local governments as well. So no matter what kind of law enforcement we're talking about, no matter what level the case is, no matter what kind of court you're in, if any law enforcement agent or any agent of the government violates your rights to find some evidence, that evidence cannot be used against you in court from then on. The next case on the list, this is one of the more famous Supreme Court cases, and for very good reason. It's a very important case in the United States. Katz v. U.S. So prior to 1967, under existing Supreme Court precedent, the Fourth Amendment only protected you from the police kind of physically touching you, your clothes, your bags, your house, your car, right? And in 1967, this case, Katz v. United States, Katz was in a phone booth. You know, if you're young, you probably don't remember what a phone booth is, but many, many years ago, all over the United States, and I'm betting all over Indonesia as well, there were these kind of physical booths with a phone in it, and you would go up and put some coins in the phone to call people because we didn't have cell phones. And Katz was in a public phone booth, and he closed the door so he could have a private phone conversation, and without a warrant, the police recorded that conversation. And based on previous Supreme Court cases, that was okay. Since the police didn't touch him, they didn't touch his clothes or his bags or his house or his phone. The only thing they did was record a private conversation. And the Supreme Court finally in 1967 in this case said, look, it's the Fourth Amendment doesn't protect us physically. It also protects us anytime we have a reasonable expectation of privacy. So anytime that an American citizen has a reasonable expectation of privacy, the police need a warrant in order to search it. And because Katz closed the door and indicated that he was expecting a private phone conversation, the Supreme Court said that the United States government needed a warrant before it could overhear that conversation and kind of seize the recording of his conversation. In 1984, US v. Jacobson, this is very important when it comes to digital cases, e-commerce especially. Any private citizen, if you're not law enforcement, you don't work for the government, you're just a private citizen, you don't need a warrant to do any kind of searches. And whatever you find isn't subject to the exclusionary rule. So if I bring my computer to a repair facility and the repair facility is fixing my computer, because computers break all the time, if they're fixing it and they find evidence of a crime, they can just give that evidence to the police. And the fact that that repair person didn't have a warrant to search my computer is irrelevant. They're not a law enforcement, they're not government, they don't need a warrant. I brought my computer to them to search. But it doesn't just apply to people I've given my computer to. There was a case, I forget when, maybe 10 years ago now. There was a case where a burglar broke into a man's house and broke into a safe in his house and found a bunch of child pornography and turned that child pornography over to the police and said where it was from and all these things. And even in that case, the Supreme Court said that person had no right to be there. If we catch him, we're going to try him for burglary. But it was not an illegal search for purposes of the Fourth Amendment and the exclusionary rule. So private parties searching your computer is never a violation of the Fourth Amendment and never subject to the exclusionary rule. Now, 1993, this case, this is confusing because I've never actually heard the name of this case spoken out loud. I've only ever read it. So I have no idea how this name is pronounced. Might be Daubert or Daubert, if it's French. I don't know. But it's something like Daubert v. Merrill Dow Pharmaceuticals. And this case was about who gets to testify in court about these kind of, digital forensics, cybercrime involves a lot of new technology and very confusing and difficult to understand concepts. So when you're testifying in court, you want somebody who's an expert to be able to come in and say, yes, I'm a digital forensics expert. I am a cyber investigation expert. I was able to find this evidence and this evidence and this evidence, and this is what that means. And you can trust me because I'm an expert. I know what I'm talking about. And here's what the science says about this evidence that I found and why the tools and techniques that I used are safe and reliable and can be used to prove that the defendant did it or the defendant didn't do it. And that standard for who gets to be an expert witness and talk about scientific conclusions and complicated digital forensics and cyber investigation stuff, the rules for that are all laid out in that Supreme Court decision. And the very, very short version of the decision says, essentially, it's up to the judge to determine whether that information would help the jury understand the situation or not. But fascinating court case, fascinating precedent. You know, I assume if you're in the audience, you're a legal student or legal expert of some kind. And if you haven't read up on that case, you should, because it's fascinating. Now, when you're doing a cyber investigation, you have to ask yourself many important questions. First, do you have consent to search what you're searching? Because if you have consent, you don't need a warrant. Because warrants, they take a long time, they take a lot of effort. So if you don't need a warrant, that's much better. So do you have consent to search? And if somebody's the victim of a crime, they will usually give you consent to search their computer or their phone or whatever device we're discussing. So if you have that consent, you don't need a warrant. But now we get into special situations about who can consent. So if I'm not home and the police ask to search my computer, can my wife give consent? If it's not my wife, let's say I just live with a roommate, can my roommate give consent to search my computer? And that gets a little trickier. But what the Supreme Court has said is that if that person has equal control over the computer, they can. Now it happens that my computer that I'm sitting at right now is essentially only used by me. So my wife does not have dual control over my computer. So if she were just my roommate, she would not be able to give police permission to search this computer because it's not partly hers. The kitchen we both use, so she would be able to give consent to search that. But if we had separate bedrooms, she could not give consent to search my bedroom. If you do get a warrant, does it cover every crime that this computer was involved in? So let's say I get a warrant for e-commerce fraud, and I seize a computer from the bad guy. I start searching it, looking for evidence of e-commerce fraud, and I find child pornography. Does the current warrant that I have for e-commerce fraud cover that child pornography? And again, there's some gray area. So you might want to look at specifically what the situation is. But the short version is that as long as you stop after you found the child pornography, if you stop, apply for a new warrant for child pornography for the same computer, and then continue your search, you're okay. The initial child pornography will be deemed acceptable. You didn't violate your legal requirements by finding the child porn when you were originally searching for the e-commerce fraud evidence. And thus the evidence you found will not be excluded. If you find data, some kind of data or communication from either from one bad guy to another bad guy or from the victim to a bad guy, the kind of how it was found determines a lot about whether you need a warrant or not. So if I'm, if the police are kind of listening to the bad guy or a suspect's data transmissions, they definitely need a warrant. But the internet service provider, there's kind of a middle person in the transmission from sender to receiver. And in the middle, the people who run that company don't, the legal protections for the information are much lower. So the sender has a lot of rights and the receiver has a lot of rights, but the companies that run the computers that handle the communication back and forth, it's a lot easier to obtain information from them. The legal standards are lower for obtaining information from that middle person. Now, again, this gets complicated, but remember how we talked about how private parties can search a container or a thing, and they don't need a warrant because they're not government agents, right? So there is a legal question then. If I give my computer to a repair person, the repair person finds evidence of a crime, repair person takes the computer to the police, the police are allowed to search any container that the private person already searched and found evidence in, right? They don't need a warrant to search the same container that the private person searched. But that decision was written, that rule was written before computers were invented. So what is the kind of equivalent of a container for this purpose when it comes to computers? Is it the entire computer? So because the private person searched some of that computer, does that mean police can search all of the computer now? Or is each individual file a container? And thus, police are only allowed to search the files that the private party searched. And that is a question that our Supreme Court hasn't answered yet. We have had lower level courts, some lower level courts make a decision one way, some lower level courts make a decision the other way, and our Supreme Court, which is the only court that can make decisions for the whole country, hasn't made a decision on that and hasn't answered that question yet. So here in the United States, it depends on where you are to determine if, you know, a computer repair person brings you a computer and says, hey, I found this evidence of these crimes. Are the police then allowed to search the entire computer, or can they only legally search the files that the private citizen searched? And then the last one, can you force someone to give up a password? This is another one of those questions that our Supreme Court has not answered. We've only had lower courts answer, and some of them have said one way and some of them have said the other. Now, what is clear is that police can force you, if you have a cell phone, right? And it has a lock on it, but the lock can be undone either with a fingerprint or with like a facial picture. Police can force you, without violating your rights, to put your finger on the thing to unlock the phone, or to take a picture of your face to unlock the phone. All the courts agree that police are allowed to do that. That does not violate your rights. But the question is, if you have a passcode, you know, like a 6-digit number or a pattern you have to swipe, can you be forced to give that information to police so they can unlock your phone? Some courts have ruled that that is a violation of our Fifth Amendment rights against self-incrimination. Other courts have ruled that it's not a violation of our Fifth Amendment rights. So hopefully these last two questions, sometime soon, our Supreme Court will answer them decisively one way or another, because the legal answer to these last two questions right now depends on what city or state you're in as to what the correct legal answer is. Now, that's almost an hour. So this is the last slide. If you have any questions, feel free to write them in chat, or maybe the moderator would let you unmute yourself and ask. But if you don't have time or you think of something later, here's how you can contact me. I'm on Twitter at cybercrimedoc, and I'm on YouTube under the name Arresting Developments. And also on this YouTube channel, I have a few of my criminal justice courses, the lectures recorded. and feel free to use that information for if you're teaching a class or you have any other requirements for it, please feel free to use that as educational material. But yeah, any questions or comments? I will go back to the moderator or our MC for the day.
All right, thank you, Prof. Jennings, for your speech. You have enlightened us with the kind of e-commerce fraud. All right, so as Prof. Jennings said, if anyone has any questions, you can ask him directly or through his Twitter or YouTube. And for this, I would like to open the Q&A session. So if anyone has a question, just shoot at it. And also, I'd like to remind you, if you are going to ask a question, whether it is in Indonesia or in English, it is okay, because if it is in Indonesia, then I will have to translate it to English for Prof. Jennings.
I should learn Indonesian, but I've been told I only speak 2 languages, English and bad English.
Right. Silakan, Pak.
Siapa ini sekarang?
Bapak ingin bertanya, silakan tanya, Pak.
Thank you. This time, my name Muhammad Yamin, and I want to ask to Mr. Kevin one question. If you look by law, a special cybercrime-based e-commerce transaction in Indonesia, maybe we call fail or success to anticipate the crime transaction. This only. Thank you for this time.
So I'm not understanding the question. What is it a failure or a success to anticipate? Like, are we doing a good job anticipating what is a crime and what is a legitimate transaction?
Yes, to anticipate cyber in Indonesia.
The short answer is everybody is failing at that because it's so incredibly difficult to try and figure out what transactions are legitimate and what transactions are crimes or frauds, kind of fast enough to do anything about it is incredibly difficult. There are certain things, companies and rules that can be put in place, but those only stop the easy ones, right? It is really difficult to do a very good job on that. So that's the bad news. The good news is I haven't seen any evidence that Indonesia is doing any worse than any other country. So that's, everybody's doing bad. And I don't think Indonesia is doing any worse than America or China or any other country, if that makes sense. Does that answer your question?
Okay, Mr. Professor Kevin, I want to ask you about the slide e-commerce fraud. After you explain about your slide e-commerce fraud, you said 84.5% of tech goods are from China or Hong Kong. I want to ask you, what are the efforts made by the United States government to face the problem about that?
What are the steps they're taking?
Okay, after you explain about your slide,
Yeah.
the title is e-commerce fraud. Active for 4.5% of tech goods are from China or Hong Kong. I want to
Yes.
ask you, Professor Kevin W. Jennings, what are the efforts made by the United States government to face the problem about that?
What are the efforts by the United States to reduce that?
To face the problem.
Yes. So as I said during the investigation part, the kind of the main job of investigating that kind of crime and preventing those counterfeit goods is up to the Immigration and Customs Enforcement Group and the Customs and Border Protection Group. And similar to the last question, the answer is depressing and sad because we can't do enough. We try to prevent a lot of these counterfeit goods from coming into the country, but it's a very small effort compared to what would actually be needed. So if you go to any major city in America, you can find street vendors selling these counterfeit goods anyways. If on eBay, you can find counterfeit goods coming, that somebody has gotten from China into the United States and is now selling in the United States already. So it's one of those issues that we have these international agreements, we have laws that say it's illegal, and we have groups who are charged with investigating it, but there's not a lot of political or law enforcement investment. They don't see it as a huge problem the same way that they see, child porn is seen as a huge problem, and human trafficking is seen as a huge problem. But both politicians and law enforcement look at, counterfeit tennis shoes or counterfeit movie DVD discs or, some other fake product, and they don't see it as important. So we don't spend enough time or energy or money on preventing all these counterfeit goods from entering the country. I would hope, I'm not a member of our current political, White House president staff, so I can't tell you specifically, but I would hope that there is an international diplomatic effort to try to get China to kind of police themselves, right? Because if we can get the Chinese government to really start caring about their companies and their citizens producing these counterfeit goods, and they start enforcing these international laws, I think that will have a much bigger impact than any law enforcement or legal remedy we can have in the United States that focuses on demand. But if we can focus on the supply with the cooperation of the Chinese government, I think that would be a lot more effective than what we're doing now. And again, I assume there is some effort to do that, but that would be way higher on the food chain than my position. Does that answer your question? Is that a good answer?
Bu, izin tadi Prof. Janing nanya ini pertanyaannya apakah sudah terjawab?
Sudah, thank you, Prof. Kevin.
Thank you. Good question.
I would like to say I'm sorry for the thudding noises because my house is being renovated right now.
Oh no!
So yeah, I would like to say sorry if there are noises on my part. So there is a question from Bu Susilawati, a lecturer from UISU. So she asks, what is the legal anticipation of America regarding e-commerce fraud?
The legal anticipation?
Yeah.
Like what will happen in the future?
That's the question. What do
you mean by the legal anticipation?
Perhaps the system that America has to anticipate e-commerce fraud. I think that's the gist.
To try to prevent it? You mean? So other than punishing offenders, there really isn't a legal way to anticipate or prevent e-commerce fraud. We have to rely on the private companies to do it themselves, because when my credit card was stolen, I did not lose any money, thankfully, but the credit card company did. So they have a financial incentive to make it difficult for people to steal credit card numbers, right? So there is very little legal requirements for prevention of e-commerce fraud other than punishing people who we catch doing it. To actually really kind of prevent it, though, ahead of time, we rely almost exclusively on companies and internet providers to kind of anticipate and prevent that kind of crime themselves. So it's all kind of voluntary and company driven rather than legal requirements.
So you can say that there is no particular anticipation in the legal system.
No, we do a lot of very strange things here in the United States. And one of them is that we rely very heavily on companies and organizations to kind of police themselves, and we want them to kind of figure out what's wrong and fix their products without us having to force them using the legal system. And sometimes that works out, but very often it does not work.
Right. So thank you for your answer, Bu Susilawati. Does that answer your question? Okay. So there is another question from Pak Dedi Wahyu Utama. Perhaps you can ask your question directly to Prof. Jennings.
Oh my gosh, so many questions. This is great. I love questions. Who was it?
Good morning, Mr. Kevin Jennings. Allow me to introduce myself. My name is Dedi Wahyu Utama, student of a master program at the Islamic University of the North Sumatra.
Nice to meet you.
Nice to meet you. So many emerging cybercrime. A law is urgently required. The right laws and the methods to prevent cybercrime. I want to ask, does your country have the law regarding cybercrime? For example, at my country in Indonesia, we have the Constitution number 19 years 2016 about the information and electronic transaction. So how about your country to preventive the cybercrime about have the legal structure or the system legal in your country?
So it's a very similar answer to the last question. Our laws focus very much on punishing people after they did the crime. So if somebody has a child porn, if they get caught with child porn, we punish them for that. But there's very little legal regulation for preventing it before it happens. We have internet service providers, the people who transmit data from one person to another. I'm not aware of any legal requirements for them to kind of focus on preventing crime. And in fact, many times we have the opposite. We have legal requirements that they are not allowed to do certain things to prevent crimes. For instance, without getting too technical, there is a way to take all known child pornography pictures and kind of get a signature or a code that is unique to just that picture, and then look at all the files that are going back and forth on the internet to see if any of their signatures or their codes match the known child porn images. And this would be a relatively simple way for companies to kind of develop suspects. It wouldn't be 100% perfect, but it would be a good start for law enforcement to know who to investigate for things like child porn. But our companies are legally prevented from implementing that system because we want our internet users to have their privacy respected. So it's kind of, many of our laws do the exact opposite. They make it kind of prevent companies or other people from trying to help prevent these cyber crimes before they happen. Does that make sense? But I mean, again, other than that, a heck of a lot of our law is only focused on punishing people after they do the crime, not there's very little law preventing people from doing it in the first place. There's a lot we can do technologically from, as websites like eBay and Craigslist and, Facebook and all those companies, they can, if they want to, implement certain things to try to prevent crimes. But the legal requirements are almost non-existent.
Right, so for the next question, Prof. Jenning, we have another question in the chat room. So this question comes from Khalis Ar-Rashid Harahap. He asked, are there any technology standards for e-commerce? And what buzzword do we need to know?
Oh my gosh, buzzwords. So technology standards, technology standards, there are a lot. And not necessarily as legal requirements, but as just kind of best practices. These different companies have figured out what they can do to help, and they've kind of developed a set of rules that all the companies should follow. Whether they actually do follow those rules, who knows? But both a buzzword and a good standard that I think every company should follow is that all communications over the internet should be encrypted. And for those who don't know, encryption means putting something into code so that only the sender and the receiver can understand it. And that means that if a bad guy tries to overhear the conversation between a credit card reader and the credit card company, they can overhear that conversation all they want, and they won't be able to unscramble the code in order to know or find your credit card number. And that is a very basic thing, but not a lot of people are doing it, because there are a lot of companies and a lot of products where they don't think about security. So for instance, in my old house, I just moved houses a year and a half ago. I was in Savannah, Georgia, which, as I understand it, has a climate very much like Indonesia. And now I am living in Tennessee, up in the mountains, where it's cold and windy, and I don't like it. But in my old house in Savannah, I had an internet-connected thermostat for my air conditioner. So if I wanted to, I could hook my thermostat to the internet and control it via an app on my phone. And when the company made this product, I'm sure they were just thinking about convenience, but they don't think about bad guys getting control over that device, or even just knowing the information and the settings, right? And because they don't think about what bad guys could do with this, but think about, you know, just from overhearing, intercepting the information about my thermostat, they could know, you know, I don't know if you guys do this, if you have, you know, your air conditioners and your heaters, when you go on vacation for 3-4 days, you set your air conditioner to what would normally be kind of an uncomfortable temperature to save yourself some money, because your house is going to be empty for 3 days or 4 days or a week or whatever, right? So just by overhearing the information about my thermostat, bad guys could find out when I'm going on vacation. And they can go and break into my house and steal a bunch of stuff, knowing that I'm not there to protect my things. Or if they wanted to just be mean, they could turn on my heater to 100 degrees, or, you know, Celsius. What's, 40 degrees Celsius? And then everything in my refrigerator would go bad, and maybe my dog would die, and, you know, it might break some other things around my house just by being very hot in my house. So even the most minor things, like a thermostat, if a bad guy can intercept the data or take control of the device, there are lots of things bad guys can do with those that aren't kind of immediately apparent. So these companies don't think about security because they don't think that they need it, but they really do. So best practices and technology standards really should start, this basic start with encrypting all communications over the internet to make it much more difficult for bad guys to intercept information or control internet devices, or any of those other kind of issues, if that makes sense. And when it comes to buzzwords, definitely think of encryption and hash cracking, hashing, hash cracking. One of the old ones that was from the late 90s, early 2000s, when I was young, one of the big buzzword was WARES, W-A-R-E-Z. That was illegally obtained software. Carding markets are the places where you can buy and sell the credit card numbers. You need to know the dark web and deep web, which again I can have a whole other lecture about that. But that's the kind of hidden area of the internet where lots of criminals kind of hang out. And if I think of more, I can send them to you. But it's very late here, and I'm having trouble thinking about good buzzwords. But I know there's got to be another million of them I could list for you.
Right. So for Kalis, does that answer your question? Right then, so we have another question for you, Prof. Jennings. I'm sorry, we have a lot of questions here.
No, that's great. I love questions. Please.
Yeah, so this question comes from one of Heylaw's staff. So she asked, electronic signature is really common right now, right? So can it be misused later, especially when there are a lot of online application that that is like credit cards, but without the credit cards, so you can pay later if you buy something online. So that is the first question.
The answer to that is these e-signatures, if they are done correctly, they're very secure. If they're not done correctly, they can be, they're not very, but if they're done correctly, which we really hope they are, they're very secure because it relies on a certain, the mathematics behind this is very complicated and I don't understand it myself. But to try not to get too technical, there's a process called public key encryption. So think about every person having two passwords or two keys that are paired together. There's a public key that everybody knows and a private key that only you know, right? Now, usually, if you encrypt something with one of the two, it can only be decrypted via the other. So if I encrypt something with my public key, I can only decrypt it with my private key, right? And this is usually used for messaging. So if I want to send a message to Maria, our MC for the evening was Maria, right? I'm so bad with names.
Yeah, it is Bu Maria.
Yeah, see Maria. Okay, good. See, I remembered this one. I'm not that bad. If I wanted to send an encrypted private message to Maria, if you had to encrypt and decrypt with the same key, it wouldn't be very secure because then I would have to know her password, she would have to know my password. But with using the public and private key pairs that are connected, what I can do is find her public key and encrypt my message with that public key and send it to her. Now, only she can decrypt it using her private key. Then she wants to send a message back to me. She encrypts it with my public key, sends it to me, and now only I can decrypt it with my private key, right? And this system has been working since the early 1990s. They've had this system of public and private key encryption. One of the other uses for this, though, is with these signatures, these electronic signatures. Imagine I encrypt something with my private key and then send it out. Now, anybody who wants to can decrypt it using my public key and read the original message, right? Now, it doesn't sound very secure, but the point in doing it this way is not to be secure in my message. I don't care who reads the message. I'm just trying to prove that the message was definitely written by me because nobody else has my private key. So if you can decrypt and read my message using my public key, you know it was me that sent it, right? So using this system, if your e-signature system uses that, where you encrypt some token thing with your private key, and then anybody who wants to can decrypt it using your public key and read your signature. If they're using that system, it's very secure because you're the only one that knows the private key in order to create the thing. And thus it can be a very accurate e-signature process. And we use that today. Anybody ever been going online and you see, there's a warning that pops up on your computer that says like this website has an invalid security certificate or something like that?
Yeah, sometimes.
Yeah, so that process is exactly what's going on with the public and private key encryption. They have, most companies will encrypt their website using their private key. And then when we go to it, we decrypt it using their public key. And that's how we can know that it's the right website. It is that company that has created it and set it up. So if somebody tries to fake that website, essentially that decryption process won't work because they didn't have the private key in order to do it. And thus the public key won't work, and thus it prevents them from trying to do that. So if the digital signature process that you're talking about utilizes that technology, it's very secure. But if it's just people going and, kind of using a draw pen or a finger on a tablet to write out their signature, and we've got to rely on that being their signature, that's a lot less secure. So it really depends on kind of the technology behind what kind of e-signature you're talking about.
Right. So the electronic signature that you mean here is the electronic signature that is some sort of a key that is publicly available for you, and the other one is privately owned by you. Is that correct?
Yes, but keep in mind that all of us use this technology all the time. It happens in the background. Your computer kind of is able to do it automatically and see if it can get the answer it expects with no real input or process by the user. So you use this technology all the time without actually knowing. So it's not something that you would kind of, if you were using it, you would be aware. It's not like that. You are using it all the time and are completely unaware of it. So you really have to kind of look to see and understand whether whatever digital signature process you're using utilizes this technology.
So that is like the encryption of WhatsApp messages or Telegram. Is that correct?
I believe WhatsApp uses that system for encrypt. I know they encrypt their messages. I'm pretty sure that it's the system I just described that they're using. They might use a slightly different system with similar results, but I know they encrypt all messages.
Right. So that is the first question of 2 questions. So the other one is the follow-up is, if our cell phones are stolen, which contains a lot of applications such as travel apps or online shopping apps, and then it also directly connect to our account, our Google account, our credit cards account, or our debit card account. And, right. So if that person who stole our phone uses that phone to buy items on the online shops, and the bill remain to us, what can we do with that?
Well, first off, I would say, please take steps proactively to prevent that from happening. I have the built-in on my cell phone. I don't know if you can see this, but I have the program where you have to put in a code. That's my wife's face, by the way. But you have to put in a code before you can open my cell phone. Please, everybody have some kind of code on their phone to try to prevent people, if you lose it, if somebody steals it, to try and prevent people from getting that information. You can then have additional apps that will try to protect that data. So for instance, there are apps that you can download to prevent people from accessing your photos, right? There's another password you have to enter, different than the one to access your phone, in order to access your camera. And then you can have another app that will protect your credit card and password information. So please, bare minimum, have some kind of lock on your phone where you have to put in a passcode or put on your fingerprint or something to prevent bad guys from stealing information off of your phone if they get it. But at that point, if you don't have the code, or if somebody has stolen it and is able to get through the code somehow, at that point, it's really going to depend on the company. It's going to depend on who was stolen from. If they stole money from your credit card, you're going to have to contact the credit card company. If they took money out of your bank account, you're going to have to contact your bank. I would hope that your police would be able to investigate and try to find whoever did it, but police everywhere are kind of overwhelmed as far as time and training and effort, so maybe not. I don't know. But yeah, at the bare minimum, it's going to be a lot of time and effort on your part to try to fix what those people break. So please take the time, invest in your phone security, and try to make it so that if you do lose your phone or if it's stolen, the bad guys can't use it. They can't get any information off of it.
Right. So you mentioned about an application that further secure your data. Perhaps you can tell us what is that application?
Oh, there are tons of them. I mean, you can just go into the Google Play Store, the Apple Play Store, and put encryption app in the search, and it will give you a ton of them. Some of them are free and have ads. Some of them cost a little bit of money, but as long as you're doing something, it's a heck of a lot better than doing nothing.
Right. Thank you, Prof. Jennings, for your answers.
Absolutely.
So, right, we have another question.
Okay.
It is also related to the previous question. So this question is about whether or not our spouse or our parents or our children is allowed to have access to our online data. I mean, can they use our phone to buy online shops, online items, and then it is billed to us? What do you think?
So that is a very good question. And I know, obviously, if you give them permission to do that, they can do it. If they do it without your permission, I'm not sure. That's something you'd have to ask an Indonesian lawyer. Here in the United States, what they would say is essentially you're in a bind. You can say it was illegal and they didn't have your permission, in which case you will probably get your money back, but the police will arrest your child or your spouse or whoever. Or you can say, no, it's okay, but then you don't get your money back. So you have to choose who you love more, your spouse or your money.
Right.
So, how exactly it works in your country, I don't know. You'd have to ask an Indonesian lawyer.
So it relies on the consent of the owner, right?
Yeah.
Right. That is the question. For all of the participants, if you have any questions, perhaps you can ask directly to Prof. Jennings. Untuk partisipan yang ingin bertanya, silahkan bertanya dalam bahasa Indonesia, nanti akan ditranslate ke bahasa Inggris dan ditanyakan ke Prof. Jennings.
I actually got in my private messages, somebody sent me a direct message asking for my WhatsApp number. And I thought I would answer for everybody. And the answer is, I don't know. I don't use WhatsApp very often. And so if I look at my my settings, it's not listing a number, it's just listing me under my name, Kevin space W period space Jennings. That's if that username is enough to send me a WhatsApp message. Please reach out to me on WhatsApp again, or via Twitter or YouTube or however, and I will be happy to answer questions and provide resources and all of the above.
So if there is no question, we can end the Q&A session. But before that, we would like to, right, so there is another question, Prof. Jennings. It is from Mr. Zaini Munawir. This question is, how is the US law regarding a bad service of application in e-commerce transaction, and how to solve that phase?
What was that?
Wait, Pak Zaini Munawir mungkin bisa bertanya dalam bahasa Indonesia dan saya akan mentranslatekan kepada Prof. Jennings.
How?
That case, okay. So his question is, how is the US law if there is a bad service of application in e-commerce transaction, and how to solve that case?
What do you mean by bad service of application?
Okay. Pak Zaini Munawir, Prof. Jennings bertanya ini bagaimana yang dimaksud dengan bad service of application. All right, so what he means is bad protection of consumer. Bad consumer protection, and how to solve that case.
So, like, if there's an application on my phone that kind of does something nefarious.
Yeah, and your data is not protected, perhaps.
Yeah, so what we would have to do here in the United States is take this to civil court and sue them. You know, go to the company and say, hey, your app did not have the proper encryption, or it didn't do this, and so I'm going to sue you for, you know, however much money I lost plus $1 million or something, and try to convince a judge that this app was not good enough to be doing what it was doing, and it either deliberately or through negligence caused me to be the victim of a crime. Then the only real remedy for that is with civil courts and a lawsuit. And that gets into a whole host of legal issues, but that gets very complicated very quickly.
Right. So that means we have to take it into our personal matters and sue. Right. Right. Oke, Pak Zaini Munawir, apakah pertanyaannya sudah terjawab, Pak?
All right. I would love to sit here and answer questions all night. I love questions. It is past 11 o'clock at night here, and I have got to go to bed. I have to go to work tomorrow. Thank you so much for inviting me. I really enjoyed this. If anybody has any more questions, please feel free to reach out. Twitter, YouTube, WhatsApp, any of those. But I have to go to bed.
Thank you.
Thank you.
Before you leave, we would like to ask you to have a picture taken together for all of us. That's
yes,
okay?
Absolutely.
Yeah. Kak Flo, can you help us?
Iya, Kak Yuan.
Can you help us take the picture together?
Kita langsung lanjut ke Pak Faisal aja, nggak apa-apa.
Okay. So last last thing, Prof. Janing, we would like to ask you whether or not we can have your PowerPoint presentation.
Yeah, absolutely. I can email that. Florentina's email, who sent me the lovely background that I used tonight. Can I just reply to that with the PowerPoint?
Yes, yes, we can send it to her.
Perfect.
So if you have to go to sleep, then we will have to say our goodbyes here.
Yes, thank you so much.
Yeah, thank you, Prof. Janing, for your great lecture. And we will have to continue.
Bye. Have fun with the rest of the presentation, and I'm sorry I'm going to miss the second part. But good night.
Good night, Prof. Jennings. Right, so for our next schedule, we have another speaker from Universitas Islam Sumatera Utara, Dr. Muhammad Faisal. He will give us a lecture about tantangan hukum di era ekonomi digital, permasalahan dalam transaksi e-commerce di Indonesia, or legal challenges in digital economic era, issues in e-commerce transaction in Indonesia. For Pak Muhammad Faisal, perhaps you can start now.
Okay, thank you, moderator. Assalamualaikum warahmatullahi wabarakatuh. Before I start, may I just, do we need to take a break or I can just continue?
What was it, Pak Faisal?
Do we need to take a break first or I can just continue? Does the participant still press to continue or how about?
We can just continue straight.
Okay, okay, thank you. Before I start, a few greetings for the respectfully Dr. Haji Yan Harja Maludin, Rector of the University of Islam Sumatera Utara, respectfully Dr. Marjuki, Dean of Law Faculty of University of Islam Sumatera Utara, dear hardworking committee that organized this beautiful event, dear all participants. What an interesting discussion from Professor Jennings. I will start a different discussion with a different perspective. Professor Jennings may start it with a criminal procedure, but I will start it in a perspective of civil procedure. In this section, maybe this is not kind of a lecture, but a discussion between participants. We'll try to discuss topics regarding common legal issue in e-commerce transaction in Indonesia. Okay, let me start the share screen. Right. In the event of commemorating the 70th milad of Law Faculty of UISU in collaboration with Heylaw. Let me start first with a brief definition regarding e-commerce. I guess the most simple definition can be found in the Oxford Dictionary's commercial transactions conducted electronically on the internet. The most brief and the most the most brief explanation, but consists all of its definition. Electronic commerce can be both products or services, which are bought and paid for over the internet, the scope from the WTO. But the products are delivered physically, and products that are delivered as digitized information over the internet. That means that e-commerce is a whole process of transaction products or service from the buying process and the delivery process. It can be both products or services or both of them, and also it can be an online auction. The business model in an e-commerce transaction can be business to business, business to consumer, consumer to consumer, consumer to business, or even public administration e-commerce. Yeah, so just a brief of definition. There are 5 common digital economic challenges in Indonesia. Cybersecurity, a healthy business competition, human resources, internet access, and regulation. These are based on the Investment Coordinating Board of Indonesia, or as we call it, the BKPM. In this discussion, I will try to discuss this matter, the legal issue of the e-commerce in the scope of these 5 common challenges. Let's start off with the regulation. The United Nations, through the World Trade Organization, have set model rules regarding e-commerce by the United Nations Commission International Trade Law, or as we call it, the UNCITRAL model law. There are 2 specific model laws from UNCITRAL in the year 96 and the year 01, where in the 96, it emphasized the legal value of computer records. And in 01, it emphasized the legal value of electronic signature. Unfortunately, in Indonesia, we have not fully adopted the model law in one comprehensive law products. Regulation regarding e-commerce in Indonesia is still scattered and varies in different acts and government regulation. Mainly, the model law adoption can be found in the Electronic Information and Transaction Act, or as we call it, Undang-Undang ITE. But in fact, Undang-Undang ITE only put these 3 values in e-commerce. First is recognizing the legal value of computer records, paper-based documents to electronic documents. That means that electronic documents is a legally binding documents. The second is to recognize the legal value of electronic signature. That means that EDI, products of EDI, electronic data interchange, the so-called data message, is a legally binding proof in court. This is what Undang-Undang ITE, as we call it, the ITE Act provide for the e-commerce. As mentioned before, the regulation is scattered everywhere. There is no one regulation regarding e-commerce. As we can see in this slide, the general regulation is still the civil law regulation, or as we call it, KUH Perdata. The specific regulations, the lex specialis, is the ITE law, the Commerce Act atau Undang-Undang Perdagangan, and Consumer Protection Act atau Undang-Undang Perlindungan Konsumen. There are 2 government regulations that govern the e-commerce transaction. The ITE Enforcement Rule, PP nomor 21/2019, and the Electronic Commerce, PP 80/2019. In conclusion, all of those regulations mentioned before promotes recognition of electronic transaction, information, documents, and signature in contracts law, and as a legally binding proof in courts. All of those regulations promote and guarantee legal certainty of electronic transaction. That's the main idea of the regulation. As mentioned before, business transaction falls under civil regulation. And contracts become the basis of parties' legal relations that help parties' rights and obligations. So we still need to address the KUH Perdata before we can start the discussion about the e-contract or electronic contract. Contract used in e-commerce activities basically adopt the same principle as contracts made in conventional transaction. That's where KUH Perdata Article 1320 is still being used in the electronic contract. Article 1.17 of Undang-Undang ITE. Electronic contract is an agreement of parties entered into by means of electronic system. The difference is only the system. Used to be by paper and now by electronic. Electronic transactions that are stated in electronic contracts shall bind on parties. This is the legal foundation of an e-contracts. That means that electronic contracts still follow civil law regulation regarding contract requirement. 1320 still exists, and there are some interesting things to mention. There are additional requirements needs by the law, required by the law before an e-contract can be said binding. ETA Act and Commerce Act offer extra requirement, not to mention government regulation. By the unilateral model law adopted in the ETA Act, the contracts need to be written. As written means that it can be read and printed by parties, not verbally conducted. That's the meaning of written. The main point is it can be read by parties and it can be printed for proof in courts. Other requirement is still the same. Consent, legal capacity, specific matter, admissible cause, and blah, blah, blah others. Other addition comes from the government regulation, especially the e-commerce government regulation. An e-contract also contains specific terms and conditions required by the law. We will come back to the TNC matter later. There are specific TNC that need to be, TNC clause, I can say TNC clause that need to be conduct in an e-contract or electronic contract. Most common contracts on e-commerce. Other interesting things to be mentioned is when does consent occurs between parties when parties never met personally and does not have direct contract with each other. By the means of electronic system, parties will never meet personally and does not have direct contacts with each other. There are three most common methods known in the world of e-commerce. The first is when you buy products directly from sellers' websites, the so-called browse wrap agreement. This is when you bought from the website, directly from the website of the seller. When you agree to the price and the method of shipping, then that means that you have agreed, you have give your consent to a mutual agreement, to the contract. The second is a shrink wrap contract. This occurs when you buy digital products. It is like a license agreement where the terms and conditions of the contract are enforced upon the consumer as soon as he opens the package. It's like when you buy a software and you agree to the terms and conditions. The third and the most common known method is the click-wrap or click-through agreements. It means agreeing to the terms and conditions of the organizer. Consent occurs when consumer click OK or click I agree button on the dialog box. This is when consent occurs in an e-contract. But there are still some matters that need to be addressed. The regulation, the law, require a standard clause that need to be contained in an electronic contract. Some of them are the identity of the parties, the object of the agreement and its specification, electronic transaction requirement, price and fees, procedure to terminate the agreement, a provision that grants a right to the damaged party to receive indemnification for any hidden defect, and the choice of law to settle electronic transaction. All of these subjects must be put inside the e-contract, or as we can say, inside the terms and conditions that must be agreed upon. Prevailing Indonesian laws and regulation do not specifically address the click-wrap contracts or whether they are enforceable in Indonesia. This is the one of the issue here. There are no laws, there are no regulation that provide a click-wrap method as consent giving between parties. Click-wrap contracts are prepared in digital format. Such contracts should at least contain the information above to be enforceable. As long as click-wrap contract contains this minimum information, they should be enforceable in Indonesia. These click-wrap contracts, these e-contracts, is known as standard agreements, or as we call it, perjanjian baku. Before we start discussing the issues, let me set some facts first. What about Indonesia and e-commerce? Indonesia is the 11th largest market for e-commerce, with a revenue of more than 33 billion US dollar in 2020, placing it ahead of Russia and behind Australia. We are one of the biggest market for e-commerce. With an increase rate of 61%, the Indonesian e-commerce market contributed to the worldwide growth rate of 29% in 2020. Just from Indonesia, e-commerce transaction worldwide increased by 29%. That means so many of our citizens transaction by e-commerce. This growth will still continue, expanding for the next few years and be propelled by East and Southeast Asia, with the expanding middle class and the lagging offline shopping infrastructure. 96.4% or 195 million Indonesians access the internet through their mobile phones. That means that almost all of Indonesians have access to internet. Not to mention the good or the bad receiver of the signal. But the fact is, almost all Indonesians is exposed to the internet. They have use the internet. Regarding e-commerce, these are the top 10 most visited e-commerce sites in Indonesia. As we can see from data, e-commerce practice in Indonesia are dominated by user-generated content marketplace. From the previous slide, we can see that there are many models of e-commerce transaction. But the most common models used by Indonesians is the business to consumer model e-commerce. From this fact, I will try to discuss the issue faced by the e-commerce in Indonesia only in this matter, only in the marketplace matters. I will try to focus the scope in marketplace issues, because the fact says that all the top 10 e-commerce sites are marketplace sites. Let's start with issues number 1, consent and standard agreement. This one can be said a classical issue faced by consumer from the first time the act is enacted. Standard clauses or standard agreement. The regulation shows that electronic system organizer or marketplace are required to submit information to electronic system user at least regarding. So this is also a clauses information that need to be submitted in the TNC. The marketplace identity, scope of transaction object, security, feasibility, procedure for using the system, contract terms, procedure for reaching agreement, guarantee of privacy, protection of personal data, and complaint center telephone number. Other than that, there are also clauses that need to be mentioned in the e-contract from the seller. Seller must give a time limit to consumer to return the delivered goods and or services provided if they are not in accordance with the contract or where there are hidden defects. Okay, before we start, what is user-generated content? Some terms might be difficult to understand because we are still foreign to technological terms. A user-generated content means that a marketplace, the organizers, is only have the obligation to provide place for seller and for consumer, or for buyer, for seller and for buyer to meet. That's what called a marketplace. The consumer here can be both seller or buyer, because the service provided by the marketplace is only a meeting place for them to do their transaction. So that means that even the buyers and even the sellers need to agree to the terms and conditions put by the organizer or the marketplace. Marketplace need to guarantee privacy and protect the personal data of seller and buyer, or as we can say, the consumer of marketplace. Many misunderstanding comes from here. People used to thought that seller have the obligation, have the seller is the marketplace. Many misunderstanding comes from there because of the different terms used in the electronic commerce. So when does consent occurs? Consent occurs when the user, both seller and customer, agrees to the term of and condition offered by the organizer marketplace. This means the click-wrap agreement, the click-wrap methods. When you click, I agree. When you click, I have read the terms and conditions. When you click, I agree. That means that you have given your consent to the contract. Consent between seller and customer occurs when the customer pays the price and fees of products. When does the consent to use the application, to use the marketplace, occurs between seller and customer and buyer? It occurs when the customer pays the price, the listed price by the seller, paid by the customer, and all the fees. Then it means that the buyer have give consent to the contract. This is proven when the customer give a check mark in the column containing that he agrees with what has been required, and customer fills out a form containing personal data. Once again, a click-wrap agreement. The Consumer Protection Act, Undang-Undang Perlindungan Konsumen, does not prohibit business actor from making standard clauses for every document or agreement on business transaction for trading goods and or service, as long as the standard clause does not include provisions that are prohibited in Article 18 of the Act. So standard agreement, standard clauses is permissible by law as long as it does not include provisions that are prohibited by the law. Then what are the issues? The common disclaimer liability clause. When organization, when marketplace decline the obligation of liability, these clauses are not prohibited by the law. It's not the clauses that mentioned in the Article 18 of the Consumer Protection Act. The most common one is marketplace is not responsible for transactions carried out by sellers and buyers on the marketplace side, because the contract is carried out directly by the seller and buyer. Once again, contract occurs two times. One with the organizer from seller and customer. The second one is with the seller and the buyer. The contracts that occurs between seller and buyer is not the responsibility of marketplace. Marketplace is not responsible for viruses or other malicious software obtained by accessing or connecting to the system. When you use the system and you are attacked by viruses, marketplace is not responsible for it. Marketplace is not responsible for any disturbance, bugs, error, or inaccuracy, also damage to user hardware from the use of service. If there are bugs, error from the application, then that is not the responsibility of marketplace. Marketplace is not responsible for the content, action, or inaction of third parties, including those related to products that are suspected to be fake. Marketplace does not have the obligation to ensure buyer that the products are real. Marketplace is not responsible for hacking action carried out by third parties to user accounts. When your personal data being hacked, then that is not the marketplace responsibility. This disclaimer liability clause become an issue when customer injured by the lack of service by the application or even by third parties. Does the Act prohibited these clauses? No. The Consumer Protection Act does not prohibit exoneration clauses and disclaimer liability clause. Even though in the practice area, there are verdicts that says that the standard clause contradicts the principle of freedom of contracts. But if we analyze the case, we can see that the clause that contradicts is either the exoneration clause or disclaimer liability clause. In reality, consumers are parties who cannot control the system. Consumer does not have access to the system. Consumer only have access to the service provided by the system. Loss caused by a third party who takes advantage of the weakness of the system cannot be prevented by consumer. If the marketplace, if the organizer being full, there is a loophole that is used by the seller or the bad person to take advantage on uneducated consumer. There are many cases like this, but in reality, in the practice area, many verdicts give the disclaimer of liability to the marketplace. Some thought on the standard clause. There are even discussion about the difference between standard clause and standard agreement. The one that is prohibited is the standard clause, but standard agreement is permissible. Some confusing facts that we face in Indonesia. Some talk of this. Standardized contracts promote take it or leave it situation to consumer. If you want to use it, then you take it. You agree to the terms and conditions. If you don't want to use it, then you leave it. This situation is what the judges call standard clause sides with organizer and place consumer in a weak position to accept conditions imposed by the organizer. This is the same as the abuse of power, which is a manifestation of an unlawful act. Manifestation. For the sake of efficiency and convenience, and to comply with the minimal requirement imposed by law, website designers, the organizer, arrange the digital contracting environment to create a practically seamless transactional cost, minimize user experience. As we can see from the facts before, almost all Indonesians access internet, or as we can say, access e-commerce by phones. That's why we need a practically seamless, the minimized cost, user experience. We need it to be fast. We do everything in a fast way. Click to consent, human-computer interface nudges humans to behave automatically without thinking, like simple machines, or in other words, If no one reads the terms and conditions, how can they continue to be legal backbone of the internet? If no one ever read the T&C, can it still be called a consent giving from both parties? This practice created the so-called illusion of consent phenomenon. We need it to be fast, we need it to be easy, we need it to be seamless. That's why we never read the term and condition. When issues arise, then we start to reread what we have already accepted. That's what happened mostly in consent issues. Does the standard clause permissible? Yes. The most issue found in the consent issue is we never actually read the T&C. We only click on the agreement. Creating the what so-called illusion of consent. Issues number two, regarding human resources and hardware. Data from the UNESCO Indonesian interest in reading is very concerning. Only 0.001. That means 1 in 1,000 Indonesians is a hard reader. And you expect us to read 100 pages of T&C. IT terms and definitions are still foreign and hard to understand. It's not that we are hard to understand things, but the terms is still foreign for us if we are not active in the IT scope. Unstable internet connection and the use of underqualified hardware. Even though most of Indonesians have access to internet, but the connection is still unstable. That's why all of those factors promotes the need of fast and seamless procedures, thus the illusion of consent. Many e-commerce disputes come from consumers that are not fully understand how the system works. For example, we can see the COD cases, the cash on delivery cases, where couriers being persecuted by customer. Back again from what have been mentioned before, the contrast occurs either between the consumer or seller and buyer with the marketplace or seller and buyer. The contracts never occurs between buyer and couriers. Couriers doesn't have any liability regarding the products. Couriers only obligated to deliver the product without harm. Sellers who understand and know the loophole of the system will take advantage of the situation and cheat consumer. Maybe not seller, but bad person who understand and know the loopholes. The ITE regulation does not require an e-commerce site to use certification authority service. There are different terms of CA, certification authority. In e-signature, it is required, but in the system, it still may be used or not used. Certification authority service in charge of verifying, checking, and proving the identity of user and customers. There's a whole different process that needs to be done. That's why data forgery that leads to fraud can only be prosecuted by criminal process. And there is no other way to prevent data forgery by consumer. I guess this is almost the same as what Professor Jennings talks about before. There are no significant way for us, the consumer, to prevent fraud. We are also focused on giving sanction to the bad person, not the anticipation. Issues number 3, regarding dispute resolution and data protection. There are 3 remedies known in the e-commerce dispute: criminal, civil, and administrative remedies. The criminal remedies stated in the Commerce Act, or as we call it, Undang-Undang Perdagangan. Article 65 says that every business actor, every pelaku usaha, is prohibited from taking goods and or services by using an electronic system that is not in accordance with the data and or information they provide. For example, data forgery. The sanction is maximum imprisonment of 12 years and or a maximum fine of 12 billion rupiah. The leg specialist from the Criminal Act. In civil remedies, a lawsuit can be about a breach of contract or consumer protection lawsuit. I will come back to this later. And for the administrative remedies, is rule or the regulation is in the government regulation regarding ETA enforcement. In the event that organizer injures the consumer may report the loss suffered to the minister. Then the administrative sanction could be or may be in the form of written warning included in the list of supervisory priorities, blacklisted, temporary blocking, and revocation of business license. What is the well-known issues in the civil remedies? Well, we come back to the civil remedies. The first, because of disclaimer liability clause, marketplace is not responsible for transaction carried out by sellers and buyers on the marketplace side, because the contract is carried out directly by the seller and buyer. Marketplace is obliged to closure user personal data information. Marketplace does not have the rights to disclose data information. To disclose personal data information may only be done with the user permit or by the means of criminal procedures. Without criminal procedure, civil lawsuit will be deemed lack of parties or wrong party lawsuit. This means that because the marketplace is obliged to save the personal data information and have the obliged to not disclose the personal data information, we as the consumer may never know the identity of the seller without doing the criminal procedure first. In this scenario, it means that civil remedies in district courts may never be done without criminal procedures. Civil lawsuit will be deemed lack of parties or wrong party lawsuit, because we only knows the true identity of marketplace. We never know when the sellers or the bad person forged his data. for fraud. On the other hand, administrative remedy also needs proof of loss suffered by consumer by the means of civil procedures. When you need to prove your loss, you need to go by the civil procedures. When you need to file a lawsuit in civil procedures, you need to know all the identity of parties. And to know all the identity, marketplace and seller or the bad persons, you need to first you need to face the criminal procedure. Only officials may ask to disclose users' personal data. Because bad person will never permit marketplace to disclose his data. That's an impossible scenario. The last issues, actually there are so many issues. There are still many issues regarding our practices, but I will only scope it in these 4 issues. The most common issues we found in e-commerce transaction. Number 4 is e-signature and cyber notary. E-signature in Indonesian shall have lawful legal force and legal effect to the extent satisfying the following requirements. So an e-signature is legally bind and when it follows the requirements. The most prominent one is the method adopted to identify the signers. E-signature need to be verified and validated by a CA, a certification authorities. What is the CA? CA is an entity below the Ministry of Information, Communication and Information, an entity that recognized from the minister to validate and give certification of signatures, digital signatures. Minister organized an entity that had certification of permit for Indonesian CA. Indonesian electronic CA required to obtain recognition from the minister. Up to now, when you check the website, the ministry website, there are only CA entity being recognized by the ministry. What about notary? Art 15 of the Notary Act in its elucidation. Notary have the authority to certify transaction conducted electronically, or the so-called cyber notary. Notary can run its authority with technology based, such as making electronic certificate in the means of verifying parties' e-signature. That means that notary have the authority to verify an e-signature. In the other hand, ministry has not yet recognized cyber notary as a CA. Based on the law, the method for an electronic signature to have a binding lawful effect, it needs to be verified by CA, by a CA. But ministry never or has not yet recognized notary as a CA. The other issues, notary are bound to the principle of tabellonis officium fideliter ex servo. Notary need to exercise his authority traditionally, which means that notary must be presented, see and hear the signing process by the respective appearers. directly at the place where the deed is read by the notary. That's the requirement for a notary deed. As we know, notary deed is a perfect proof in courts. But referring to the provision of Article 5 of ETR Act, an electronic deed does not have the perfect power of proof like an authentic deed. To be an authentic deed, then the notary must be presented. What it means? It means that up to now, electronic deeds are only considered as private deeds, which are equated with documents, letters, and electronic certificates. E-signature certification by notary means that the deeds will lose its power as an authentic deeds and will be considered as a private deed that still needs recognition by each parties. That means transactions that need authentic deeds cannot be done electronically. In the practice area, economic sections such as bank and investment has already recognized e-signature verified by CA by using, for example, Privy.id, one of the CA recognized by the ministry. Other sections that needs an authentic deeds have not fully recognized and implemented e-signature. For example, land registry body. When the transaction needs to be done in an authentic deed, then e-signature is not yet recognized. Okay, maybe that's what I can talk about regarding this matter. Thank you, and I'll give it back to the moderator.
I'm sorry, organize. Thank you, Pak Muhammad Faisal, for your great lecture of e-commerce in Indonesia.
Actually, it's not a lecture, it's kind of a discussion, maybe you can say it like that.
Yeah. Kind of a speech lecture. Okay. Perhaps if the participant would like to have questions, you can ask Pak Muhammad Faisal directly.
Okay, are there any questions? Maybe we can start the questions, the Q&A with bahasa. So will be easier for both of us.
Yeah, that will be also okay. Oke, kalau ada yang punya pertanyaan, silakan bertanya langsung kepada Pak Muhammad Faisal.
Okay, Muhammad Faisal, I want to ask you about in November, Indonesian state has signature about the ASEAN Agreement on Electronic Commerce. I want to ask you, what are the efforts made by the Indonesian state after the ratification of the ASEAN Agreement on Electronic Commerce? Can you hear my question?
Oh, okay, thank you, Bu Nur. Does it need to be answered in English or maybe in bahasa, Ibu?
Up to you.
Oke, lebih gampang dengan bahasa Indonesia. Jadi mikirnya juga nggak perlu ditranslate lagi, Bu. Izin, Bu. Bagaimana dengan ratifikasi, bukan ratifikasi ya, tapi persetujuan pengakuan e-signature, tanda tangan elektronik di perdagangan Asia. Sebenarnya dari Undang-Undang ITE saja dengan PP-nya kita sudah mengakui keberadaan e-signature atau tanda tangan elektronik. Namun ketika kita hadapi dengan masalah hukum, e-signature hanya dinilai sebagai persetujuan di bawah tangan. Tidak ada kekuatan mengikat sepertinya akta otentik, walaupun e-signature itu diotentifikasikan oleh seorang notaris. Nah, karena notaris pada saat itu tidak ketemu langsung, tidak melihat langsung, tetapi melalui fasilitas elektronik. Nah, inilah yang disayangkan. Jika konsep cyber notary ternyata bertentangan atau undang-undang jabatan notaris ternyata memiliki pelaksanaan yang berbeda dengan peraturan Menkominfo atau dengan PP Perdagangan Elektronik. Jadi belum ketemu. Ini sebenarnya salah satu isu yang perlu kita hadapi juga. Legislator kita sepertinya belum duduk bersama untuk menentukan arahnya ini sebenarnya mau kemana. Tetapi karena kebutuhan yang sangat cepat, kebutuhan kita dalam menggunakan fasilitas e-commerce yang sangat cepat, bahkan di 2 tahun terakhir ini peningkatannya sangat tinggi, maka mau tidak mau harus ada dulu peraturan pelaksanaannya. Yaitu salah satunya melalui sertifikasi tanda tangan yang dilakukan oleh Menkominfo. Jadi pada dasarnya sudah diakui, cuma kekuatannya lah yang bermasalah. Mungkin seperti itu, Bu. I see there's a question in the chat.
Yeah, Pak Muhammad Faisal, there is a question from M. Khalis Ar-Rashid. This question is, the ITE law sufficient in answering all problems regarding e-commerce?
Thank you for the question. The brief answer is no. The ITE only put legal basis on e-commerce transaction. That means that all documents, all data message produced by the EDI is a valid and legal binding documents. That's what the ITE use for e-commerce. The others regulation, as mentioned before, it is all scattered around. There's no one regulation regarding e-commerce. The other regulation, you can see it in the Consumer Act and its government regulation. The government regulations state that requirement, what is the legal requirement to perform this system? But back again, there is no beside the certification authentication authority, there is no other means to prevent what the problems or issues regarding e-commerce. Maybe that's my answer. Thank you, Khalis.
Does that answer your question, Pak M. Khalis? All right, perhaps we can go to the other question. There is a question from Pak Teguh Yudi. Oh no, there is a question from Bu Gema Rahmada. Her question is, fungsi YLKI adalah melindungi hak-hak konsumen. Jadi sejauh mana YLKI dalam melindungi hak-hak konsumen? Apakah mengawalan KLI sampai konsumen mendapatkan hak-haknya? Terima kasih.
Oke, terima kasih pertanyaannya Kak Gema. YLKI sebenarnya salah satu yang sangat proaktif kalau bisa dikatakan dalam mencoba menyelesaikan masalah e-commerce ini. Namun, apakah tadi pertanyaannya sangat bagus sebenarnya, bagaimana pengawalannya sampai konsumen mendapatkan hak-haknya? Dalam praktiknya, dalam beberapa kasus yang boleh dibilang saya hadapi, bisa dikatakan dalam proses BPSK, misalnya gugatan BPSK, tidak pernah dihadiri oleh pengusaha, tidak pernah dihadiri oleh pelaku usaha. Karena mereka sudah mengerti, BPSK pasti memenangkan konsumen. Nanti pertandingannya adalah ketika dibanding di pengadilan negeri. Barulah keluar kurang pihak atau pihaknya salah. Rata-rata seperti itu. Kenapa bisa seperti itu? Kembali lagi, karena data penjual tidak mungkin dibeberkan oleh pengusaha, pelaku usaha, kecuali atas laporan polisi. Jadi, jika kita berbicara BPSK melalui YLKI dan lain-lain, yang pada dasarnya masih tunduk pada hukum acara perdata, maka penegakan hukumnya masih tanda tanya. Namun, apresiasi buat cyber unit kita, criminal proses bisa terjadi sangat cepat. Jadi ada pimpang di mana remedi penyelesaian dalam bidang perdata tidak sesuai harapan. Orang lebih memilih untuk penyelesaian secara kriminal karena ujung-ujungnya pasti balik lapor polisi. Mungkin seperti itu. Terima kasih.
Thank you for the question, Bu Gema. The next question for Pak Muhammad Faisal is from Pak Zaini Munawir. This question is, how model solution law enforcement in Indonesia about system cash on delivery payment in application e-commerce transaction? He would like to know the jurisprudence of that particular case.
Okay, thank you for the question. Sebenarnya, apakah ada kasus-kasus COD? Bisa dibilang seperti itu. Kasus yang banyak kita hadapi ini bukan berujung kepada perdata, tapi berujung kepada pidana. Penganiayaan oleh konsumen kepada kurir dan lain-lain. Kalau kita perhatikan, saya juga ada membaca, saya ada mengikuti juga Instagramnya membaca Instagramnya Heylaw, pernah dibahas juga oleh Heylaw dalam beberapa post dia. Masalah COD sebenarnya kembali lagi ke masalah kontrak perdata. Jadi 1245, 1246 KUH Perdata bisa digunakan. Bagaimana breach of contract antara seller dan consumer bisa digugat. Kembali lagi dari mana consumer bisa memiliki data mengenai penjual. Inilah yang menyebabkan rata-rata kasus seperti ini berujung kepada pidana. Walaupun pembahasan kita civil remedies atau penyelesaian secara perdata lebih diminati oleh consumer karena ada stigma takut lama, takut mahal dengan laporan polisi. Tapi kembali lagi, sistem COD juga pasti kembali lagi ke criminal remedies. Apakah ini diakui? Pertanyaannya ya, saya baca ulang. Model solution law, apakah ini cara yang diakui? Jadi berdasarkan PP e-commerce dan juga berdasarkan UU ITE, apalagi berdasarkan Unsitra Law, model law, berbagai cara yang dibutuhkan ini diakui karena di dalam proses e-commerce, dari offer, dari penawaran, dari pembayaran sampai dengan pengiriman juga masuk ke dalam ranah e-commerce. Jadi emang diakui caranya dibolehkan karena berdasarkan kontrak. Mungkin seperti itu, Pak Jani.
Baik, terima kasih atas jawabannya dari Pak Muhammad Faisal. Apakah Pak Zaini sudah terpuaskan dengan jawaban yang diberikan? Baiklah, selanjutnya ada pertanyaan Pak dari salah satu anggota Heylaw. Ini tentang NFT, tentang lebih ke data pribadi lah. Ini kan lagi NFT itu kan lagi viral ya di Indonesia. Terus ada orang yang salah satu yang memviralkannya itu namanya Gozali. Nah, itu kan dia upload foto pribadi dan dijual melalui NFT. Nah, itu bagaimana kalau misalnya KTP ataupun e-KTP juga diupload seperti itu? Bagaimana itu perlindungannya dalam NFT ini, Pak?
Oke, belum ada legal basisnya di Indonesia. Saya bisa katakan seperti itu. NFT kita mengupload, tapi semua orang bisa melihat. Kita mengupload hasil karya bisa dikatakan sebagai intelektual kita, hak intelektual kita, dan bisa diakses semua orang. Bagaimana jika ternyata data pribadi yang diupload? Ini remedinya pasti ke arah kriminal. Kembali lagi, kita harus mencari data pengupload yang memiliki fasilitas instrumen untuk mencari identitas. Itu hanya ada di cyber unit Polri, mungkin bisa dikatakan seperti itu. Lebih parahnya lagi, jika ini kaitannya dengan pengupload internasional, maka mau nggak mau kita harus ke Polri, tidak bisa di Polda lagi. Cyber unitnya harus yang emang yang paling mumpuni gitu. Ini menjadi masalah, betul-betul menjadi masalah. Apalagi di dunia internasional, tidak hanya di Indonesia, bisa dikatakan banyak artis, terutama artis seni rupa yang menggambar, kemudian menarik kembali semua uploadan fotonya, gambarnya, karena dijual dengan bebas melalui NFT oleh pihak-pihak yang tidak bertanggung jawab. Civil remedies-nya belum ditemukan, tetapi criminal sanction-nya pasti ada. Namun NFT ini sebelumnya harus memerlukan pengakuan dulu di Indonesia. Jadi emang sangat sulit, ini sangat pertanyaan yang sangat modern, yang memang mungkin belum bisa dijawab saat ini. Tetapi proses-prosesnya pasti ada. Mungkin seperti itu ya.
Baik Pak, terima kasih atas jawabannya. Saya punya pertanyaan pribadi nih Pak. Tadi kan Bapak ada mention kalau tanda tangan online itu sudah sah ya jatuhnya. Nah, saya bingungnya ini kalau misalnya tanda tangan online yang dipakai untuk dokumen-dokumen yang dikirim juga dengan online, terus misalnya disalahgunakan, dan misalnya tanda tangannya ini emang kan udah kayak dalam bentuk PDF biasanya ya. Kalau misalnya dipakai sama orang yang tidak bertanggung jawab, itu bagaimana Pak?
Jadi makanya ada metodenya, ada metode bagaimana tanda tangan online itu bisa diakui sebagai hukum. Pertama itu melalui CA, Certification Authority. Jadi seperti misalnya kalau kita yang paling umum digunakan di dunia perbankan itu rata-rata privy.id. Istilahnya itu kita membeli token, kita membuat akun, satu nomor KTP, satu akun. Membuat akun, nanti pengupload dokumen juga memiliki akun. Jadi misalnya perbankan, dia sudah memiliki akun, dia masukkan dokumennya, terus terenkripsi, seperti kata Prof. Jenning tadi, kembali lagi seperti itu, terenkripsi, dan terkirimkan ke kita. Guna dari verifikasi itu adalah menyatakan kalau memang benar kita yang menandatangani. Bagaimana jika tanda tangan itu ternyata disalahgunakan oleh pengupload dokumen? Maka itu bisa dimintai pertanggungjawaban baik secara perdata maupun pidana hanya kepada orang yang mengupload. Misalnya bank A, karena yang rata-rata praktis yang dilakukan itu hanya di dunia perbankan. Bank A mengirim dokumen kepada kita untuk ditandatangani. Bukan berarti kita langsung menandatangani, kita scan, kita kirimkan balik. Itu tidak diakui sebagai tanda tangan elektronik, tapi itu hanya kopi dokumen. Yang diakui sebagai tanda tangan elektronik ketika Bank A mengirimkan dokumen melalui suatu aplikasi. Kita juga memiliki akun aplikasi itu, kita buka, terenkripsi, bahwa dokumen ini hanya bisa sampai ke kita oleh Bank A. Benar Bank A yang mengirimkan. Baru kita tanda tangani menggunakan akun kita, terenkripsi, bahwa memang benar kita yang menandatangani. Baru dokumen itu dikembalikan ke Bank A. Jika kemudian hari diketahui dokumen itu ternyata tersebar, pertama kita lihat jenis dokumennya. Apakah memang dokumen yang dirahasiakan atau memang dokumen umum yang digunakan sebagai bentuk pengawasan, misalnya seperti itu. Jika memang dokumen yang dirahasiakan, maka banyak jalur hukum yang bisa ditempuh. Nah, mungkin seperti itu. Jadi e-sign ini lebih untuk menentukan benar atau tidak saya yang menandatangani. Bukan oleh karena itulah legalitasnya ada sebagai akta di bawah tangan. Nah, mungkin seperti itu. Apakah?
Oke Pak, saya lumayan mengerti ya yang dimaksud dengan Bapak. Berarti itu dipakai bukan untuk akta di bawah tangan ya Pak, tapi itu untuk memastikan kalau itu tuh Bapak yang menerima dokumennya.
Ya betul, memastikan kalau saya yang menandatangani dan saya memang betul dia yang mengirimkan.
Oke, terima kasih Pak atas jawabannya. Untuk partisipan yang lain, jika ada pertanyaan, silahkan langsung ditanyakan saja kepada Pak Muhammad Faisal.
Jika tidak, mungkin kita bisa selesaikan sebelum waktu sholat zuhur di Medan, soalnya udah mau dekat gitu. Biar bisa pas endingnya juga, kalian kita langsung
Oke, kalau kayak gitu mungkin ini pertanyaan terakhir ya Pak dari Pak Dedi Wahyu. Ini pertanyaannya terkait produk pemerintah yang sekarang menggunakan tanda tangan elektronik. Apakah perlu dilaksanakan proses certification authority?
Terima kasih pertanyaannya. Iya, betul Pak. Agar bisa diakui sebagai tanda tangan elektronik yang diakui berkekuatan hukum, maka harus melalui aplikasi yang diberikan oleh CA, suatu entitas yang namanya Certification Authority. Jadi emang harus melalui itu. Praktik umum yang kita ketahui, suatu dokumen kita tanda tangani, terus kita scan, kita kembalikan. Itu bukan praktek electronic signature yang diatur dalam Unsitral dan diatur dalam Undang-Undang ITE. Itu layaknya fotokopi dokumen, tidak menyatakan keaslian kalau memang benar kita yang menandatangani. Yang bisa menyatakan keaslian kalau memang ini benar ditandatangani oleh para pihak, itu harus melalui sertifikasi. Di Indonesia ada 9 badan sertifikasi yang diakui oleh Kemenkominfo. 2 badan publik, badan BUMN, 7 pribadi. Jadi menggunakan sertifikasi juga berbayar. Dan mereka memang berhak sesuai hukum berhak untuk menerima pembayaran atas jasa mereka mensertifikasi. Jadi ya mungkin seperti itu Pak. Jadi memang perlu menggunakan CA, Certification Authority itu.
Baik, karena sudah mendekati zuhur dan Pak Muhammad Faisal juga ingin melaksanakan sholat zuhur, mungkin Q&A-nya akan saya akhiri sini. Terima kasih Pak Muhammad Faisal.
Terima kasih.
Sudah memberikan kita penjelasan tentang e-commerce dan hukum perdatanya. Setelah ini saya akan mengembalikan kepada Ibu Maria Rosalina untuk melanjutkan jadwal acara ya Bu. Terima kasih.
Unmute.
Maaf Bu Maria, suaranya masih belum di unmute.
Oke.
Baik, terima kasih Muhammad Yuan Fenli. Sampai pada saat ini di ruangan kita ini di Zoom Webinar Internasional, partisipannya berjumlah 60 orang. Kita harap stay here tetap sampai penutupan karena kita akan ada game yang akan dibawakan nanti oleh Mbak Flo. Begitu kan Mbak Flo, yaitu nanti akan yang menang akan mendapat saldo digital. Please Flo, bagaimana ini sistemnya? Ya silakan. Kita mungkin tebak lagu ya, tebak sing. Ya.
Terima kasih Mem Maria. Selamat siang Bapak Ibu dan rekan-rekan kalian. Ini mohon maaf nggak internasional karena sama seperti dari tadi off cam, jadinya kita kembali ke bahasa Indonesia. Kita akan seru-seruan bareng untuk menyambut ke-70 tahun Universitas Islam Sumatera Utara. Kami dari Heylaw mengucapkan selamat hari ulang tahun atau milad kepada Universitas Islam Sumatera Utara, begitu. Kali ini kita akan main tebak lagu. Nah, nanti untuk Bapak Ibu sekalian boleh untuk mengaktifkan kameranya, kemudian mengaktifkan fitur raise hand. Nah, nanti kalau udah fitur raise hand-nya diaktifkan, itu nanti Flo akan ask to unmute supaya nanti juga dibantu sama tim supaya bisa ngejawab gitu ya. Nah, ini Flo matikan terlebih dahulu fitur chat-nya. Jadi nggak boleh jawab lewat chat ya. Jadi nanti seru-seruan bareng.
Raise hand ya.
Okay. Ini ada 2 ya Mem ya. Jadi harus berebut nih Mem ya.
Iya.
Oke.
Dekanat boleh ikut nggak Mbak Flo?
Gimana?
Dekanat boleh ikut ya kan?
Boleh. Bapak Ibu silahkan. Ini yang milik Mem Maria loh lagunya Mem Maria, jadi harus
favoritnya Flo.
Enggak, favoritnya Mem tadi Mem ya. Oke, baik, kita mulai yang pertama.
Mungkin yang ditebak apa judul lagunya Flo?
Ya, judul lagunya sebentar, sedang.
Please raise your hand. Silakan tangannya.
udah ada yang raise hand ya, Mem ya. Kita coba tanya.
Udah ada tuh Flo tadi. Mbak Dedi
Yang
atau siapa
pertama,
yang duluan?
Dedi ya, yang pertama ya tadi ya. Betul nggak?
Iya, sepertinya.
Oke. Oke, Kak Dedi, boleh perkenalan diri dulu ya. Mungkin Flo juga tadi belum kenal nih Kak Dedi nih.
Siap.
Dari mana gitu kan, boleh.
Siap, nama Heylaw.edu Utama.
Ya.
Dari UISU.
Iya, iya dong.
Magister. Magister ya.
Oke.
Magister. Iya.
Judulnya?
Wih jadi permadani.
Dari siapa kalau boleh tahu?
Eksis.
Bener nggak ya, Mem? Kira-kira bener nggak sih?
Iya, eksis.
Karena
Dipilarin sama siapa? Dipilarin sama siapa? Kira-kira Mbak Dedi? Siapa yang viralin ini yang heboh di TikTok?
Yang dari Jogja
tuh?
itu, yang anak muda pakai gondrong itu siapa namanya? Di aransemen ulang, dinyanyikan ulang.
Oke.
Semuanya.
Iya.
Jadi bener nggak, Mem, jawabannya, Mem?
Bener.
Oke, selamat buat
Zidan namanya, Zidan Bang Dedi.
Zidan Bu, ya.
Si gondrong di Jogja. Next
Oke.
Flo.
Iya. Baik, ditunggu ya Kak Dedi sebentar, jangan kemana-mana dulu, kita saksikan dulu untuk soal yang kedua. Nah ini boleh turun raise hand semua, kita ulang lagi. Ini soal terakhir, ayo semuanya bisa ya. Betul, Mem. Ini kita lower hand dulu, kemudian coba. Ini soalnya lucu pilihannya Mem. Nih ya, kita langsung dengerin sebentar.
Raise hand-nya mana? Ayo, where's your raise hand, please?
Gimana, Mem? Apakah udah ada yang raise hand?
Raja Irawan, Sen.
Oke, ternyata ada yang anak TikTok nih. Anak TikTok Ibu Gema nih udah goyang-goyang gini, luar biasa kita. Harusnya Pak Marzuki kalau besok di UISU ada ini, lo yang instruktur senam nanti.
Iya, bener itu Mr. Din, awet muda.
Jauh dari Bali. Oke, langsung aja kita sapa terlebih dahulu. Halo Kak Rajo Irawan, Hamonangan.
Halo Bu. Ya Bu.
Iya, masih Kakak. Ibu.
Oh Kak. Ya halo Kak.
Iya, siap. Halo Kak Rajo, gimana kabar hari ini?
Alhamdulillah sehat Kak. Kakak gimana kabarnya?
Baik, Kak Rajo. Ini dari mana nih Kak Rajo?
Dari Sibolga Kak.
Oke, baik, dari Sibolga ya, betul ya?
Sibolga itu jauh itu Flo.
Oke, jauh. Jauh rupanya ya Ibu ya?
Jauh kali pun.
Jauh kali pun. Oke, langsung aja nih Kak Rajo, apa nih jawabannya?
Judul lagunya Kak, Aca-aca nih ini.
Siapa nih yang nyanyi? Kok tahu-tahu aja?
Dadido.
Siapa? Dadido.
100 untuk dirimu Bang Rajo.
Oke, luar biasa.
Oke.
Keren-keren ini ya.
Iya.
Semua ya Memros ya. Memros.
Iya, Memros. Iya pasti itu nggak apa-apa, never mind. Ya.
Oke.
Ya selamat ya, selamat kepada para pemenang. Untuk hadiahnya nanti ada berupa saldo digital. Silakan hubungi Minhei melalui direct message Instagram dan sampaikan kalau kamu itu sudah memenangkan door prize pada webinar internasional Kerjasama Fakultas Hukum Universitas Islam Sumatera Utara dengan Heylaw.edu. Ya, Bang Rajo jangan lupa, Bang Dedi jangan lupa. Salam sehat selalu, nice to see you. Lain kali kita lebih banyak gamenya ya Kak Flo ya. Ya. Mungkin kita masuk ke closing, Kak Flo? Ya. Oke. Baik, kita akan memasuki closing webinar kita. With the completion of the core agenda, the international webinar then finally comes to an end. Thank you for your attendance and participation. Kalau ada sumur di ladang, bolehlah kita menumpang mandi. Kalau ada umur yang panjang, bolehlah kita berwebinar lagi. Ya. I am Maria Rosalina, Master of Ceremony today. I'm really sorry if you found words that are not properly used or that made you a little bit confused. Wabillahi, assalamualaikum warahmatullahi wabarakatuh. See you. Thank you, Claude, and thank you all participants.
Assalamualaikum warahmatullahi wabarakatuh. Hari ini Jumat 7 Januari 2022, UISU genap berusia 70 tahun. Usia yang sesungguhnya sudah sangat matang dan syarat dengan pengalaman. Di momen milad UISU yang ke-70 kali ini, izinkan saya selaku Rektor Universitas Islam Sumatera Utara mengingatkan kembali garis perjuangan UISU, wijahah UISU yang sudah ditorehkan oleh para pendiri terdahulu untuk menjadikan UISU sebagai perguruan tinggi yang islami, handal, teruji, bermartabat mulia, dicintai masyarakat, dan diridhoi Allah Subhanahu wa Ta'ala. Dengan segala pencapaian, inovasi, dan prestasi yang diraih saat ini, UISU tidak boleh puas dengan segala pencapaian itu. Tetapi lebih jauh dari itu, pencapaian UISU kali ini harus diukir dari sejauh mana kemampuan kita mampu memberikan kontribusi yang maksimal kepada masyarakat, stakeholder, dan juga pemerintah dalam bingkai kegiatan Tridharma Perguruan Tinggi dan Dakwah Islamiyah. Kepada seluruh keluarga besar UISU, mari kita sama-sama bekerja, sama-sama melengkapi, dan saling mengingatkan untuk meraih tujuan bersama. Kita percaya bahwa perjuangan dan sinergitas yang kita lakukan saat ini akan menjadi kebaikan buat kita semua dalam rangka mencetak generasi-generasi Islami yang mampu beradaptasi dengan segala perubahan zaman serta berbuat untuk kemaslahatan umat. Harapan kita semoga milad UISU ke-70 ini menjadi momen untuk membangun sinergitas seluruh keluarga besar UISU menuju UISU sebagai perguruan tinggi dengan predikat unggul, sehingga kita mampu bersaing secara regional maupun internasional. Maju dan jayalah UISU. Wassalamualaikum warahmatullahi wabarakatuh.